Boom. Hey, folks. I appear to have an echo. There we go. We'll fix that. Um, how's everybody doing? Hopefully, everybody's having a better week than I've been. Um, somebody says new boom. Yes, it is a new boom. So, I had some people say the boom is too long, and they weren't wrong. Um, so I got a new boom. It is now the old one was like 30 seconds long. The new one is 17. So new boom. Um, which I think is an improvement overall because, yeah. All right. I am going to send myself some relevant pictures here. So that I can possibly share them with you guys. That is, yeah. So if you're wondering where I've been, and if you're wondering why I don't have the lighting, I don't know why the lighting is. My ring light has died. It crapped out. So that is what it is. The other thing we've got here is I had a basement flood. And if you're thinking, oh, that's not so bad, it's just a basement flood. Yeah, it was a bad basement flood. It was not good. And so I've been dealing with that. That's why I've been away. And now I've got all of these things that need to get done. Like need to get done and are not yet not yet done. So I am going to be what is it? I am going to be working for probably until like 3 a.m. tonight because I got to get some stuff done. But yeah, it still exciting. So I should set a goal, and the goal is going to be for basement disaster picture. So give me 1 second here. I'm just going to set up a goal. Let's see. Goal for basement disaster photo. That way you guys can share in my what do you call it? Share in my misery for that. So how deep did it get? About 6 inches. And I know that's what she said, but yeah, that's about where that was. So, and the thing is 6 inches is deep enough. Somebody's going to clip that, but it's enough to soak into the drywall. It's enough to soak into the insulation within the walls. It's enough to soak into the bed. So bed not good. What is it? Oh, this is fun. Oh, damn, that's terrible. Insurance pay for restoration crew. So somehow our insurance got set to less than it should be. And I say somehow, I know how. It's a long story. And it's not super productive to go into all of it. But anyway, the insurance was less than it should be. So what ends up happening is the insurance company initially was like, hey, we're going to, we're going to send some people to do restoration work. And so we got their number, like we got them, they were, coming in, they were doing all this stuff. And, at least that was the idea, is that they'd come in and do all the stuff. So instead, they came by and they looked around and they said, okay, here's our sort of take on it. And then insurance called back and they were like, we need to do a virtual tour of your basement. So I was like, and then the real fun thing is the insurance guy was like, we can do the tour 45 minutes early. And I'm like, I can't do the tour 45 minutes early. I am still driving to my house because I can't live there right now. So I'm not staying there. So I'm on my way. And they're like, well, we want to do it 45 minutes early. And I'm like, I can't because I'm not there yet. And so they're like, well, we need to. And I was like, I can't. So they're like, well, okay, I guess we don't actually need you to because we're just going to pay out the insurance policy limit. Now you might say, yay, they're paying out policy limit. That is not actually a good thing because when they're paying out the policy limit, what that means is that your damage exceeds the insurance. And when they pay out the policy limit right away, it means that, like, looking at it, they're like, yeah, this is obviously way worse. So paid out. So they paid it out. Now, here's the problem when they pay out your policy limit is that then you call up the people who are supposed to be coming by to help do the repair and the emergency, like whatever. And you're like, hey, when are you guys going to get here? And they're like, oh, yeah, we're not. We're just not. And I'm like, what do you mean you're not? They're like, well, we're not because you got paid out policy limit. So the insurance isn't going to pay for us. And I was like, no, but I can pay for you. Like, I can pay you guys. And they're like, yeah, here's the thing. We want to do work for insurance companies. So now that the insurance companies paid you out, we don't want to do the work for you. We're going to do other work for the insurance companies. And I'm like, what the fuck? So that had me calling around to try to find, like, literally anybody who would help. And that was difficult. Somebody who is a viewer of the channel managed to find a dehumidifier for rent. So I got a dehumidifier for rent. You know what the other thing I did is? I literally had to, like, I bought a dehumidifier. Like an industrial size dehumidifier that runs out into a pipe, like into a hose that, I bought one because there was no other option. I got it off like Amazon. It's like some Temu special. It is a like 20 gallon a day dehumidifier. But now I own one. Because the rentals were just not happening. So finally I called around and I managed to reach a company that was like, yes, we will do this for, we'll do this. We'll take your money. And then they're like, and we're too busy. And I was like, well, shit. When can you get here? And they're like, Monday. I'm like, okay, well, Monday is better than never. And then they called back and they're like, we have one guy. We can send one guy. And I was like, I'll take the one guy. Now, me and Mrs. Runkle, had been doing work already. And I say me and Mrs. Runkle, a lot of it was me, but Mrs. Runkle was a huge help. It was easier for me to take the time off work. So I took the time off work. I was, and what that meant was hauling carpet because the carpet, once it gets soaked, especially once it gets soaked with disgusting flood shit, is ruined, right? You just cannot fix it. And so, like, and the carpet, once it's flooded and soaked, is so fucking heavy. Like, I was cutting pieces out that were like, 2.5 foot squares. And that was like what I could carry because they just weighed a ton. And then you also have to pull out the underlayer, which is, foam. So all of that had to go, right? And so I got all of that carpet out. And we hit the goal. So let me find a picture here. I'm just going to get a picture ready to go. What's a good picture? Let's see. Yeah, here's a good one. I'll just get that shared. Just take a second. So yeah, I had to haul all of that out. But the thing I wasn't really going to be good at was the drywall and insulation. So that was like, this is going to be an absolute nightmare. So this is my bedroom. Now, you might be noticing that the, what is it? You might be noticing that there's no bed in there. The carpet is gone. The concrete is filthy. Like, we're going to have to wash that. That's going to be miserable. But this guy who showed up was absolutely a hero. This guy shows up. He's just this one guy. He looks like he's a fairly skinny guy. And, but he's like, can I do work? And I was like, yes, come on in. And this guy just hammered away. Like, he was hauling soaking wet insulation out. But yeah, that's what my basement looks like. That mallet that you see at the bottom there, that yellow mallet, Mrs. Runkle used that to help dismantle the bed frame because the bed frame got soaked and then it was rusting. So that had to go too. But what do you call it? So we couldn't find a mallet for that. So that's one of my leatherworking mallets that I went to get in and get that together. We had to take apart the bed and haul that out. There is a pile of garbage outside. It is like as tall as I am. What about the mattress? The mattress had to go because the mattress got soaked. So the bed frame wicked water up into the mattress, and then the mattress had to go too because it got soaked with disgusting goo. So no saving that. What is it? No, the insurance is not enough. So I'm not sure what the plan is at the moment because, there are several ways to dry a mattress, not when it was soaked with like storm water. So what was the cause of the flood? Don't actually know. Because the other fun thing is that this flood happened while I was away. So, what is it? I went to Seattle area and I was having a good time. And then we heard that there were record floods out here. Like record rainstorms, and somebody posted on the Facebook page that that there was like water like all through the street. Who sleeps in the basement? I do. Basement is awesome. When it's not flooded, the basement is an awesome place to sleep. And I will tell you why. Um, the basement stays cool when everything else is way too hot. The basement is a great place to go and so yeah. But it's not so good when it floods. So that was less good. But yeah. Do I have an Amazon wish list? I have not set up an Amazon wish list for stuff we need. And the reason why is that right now we are not yet to a place of moving back in. How much is the insurance not covering? I don't know yet. I don't know yet. And the reason why I don't know yet is that we're still fixing everything. Do I have a sump pump? Yes, we have a sump pump. And the sump pump was working. So, ironically, the sump pump, well, not ironically, but the sump pump actually, what is it? The sump pump pumped out the flood. So we could tell that it had been up to 6 inches in here because of like water line from from various, like you could see the water line where it had left. But when we came back, the sump pump had pumped it all out, but the carpet was soaked, everything else was soaked. So, you just, stuff had to start going. So, what is it? Do I have a Venmo or PayPal? I do have a PayPal. I also have set up another goal, and this is a goal for a proof of life photo. I've been teasing you guys a little bit. What is it? Wait, sump pump survived? The sump pump survived. The sump pump is still pumping out water. And, it's still like that is helpful, but I also don't yet have the big announcement. The big announcement is coming soon, I hope. Very much hope. But people are asking, how are the puppies doing? So Mrs. Runkle and I are staying with her family, and the pups are there. So the pups are not like running around in the the wrecked basement and the goo and the gross, because like we're gonna have to mop up all that silt. It's gonna be really unpleasant, and whatever. But yeah, I can't set up Zelle because I'm Canadian. Need an American account, but CIBC and others are easy to set up an American-based account. Okay, I'll have to look into that. So yeah. Good thing I didn't lose my electronic equipment. My computer's up here. Mrs. Runkle's computer was downstairs. But it was on a thing. And so Mrs. Runkle's computer is fine. And so yeah. Riveted by the facts is love meeting you and Mrs. Runkle in Seattle. Sorry this mess is what you came home to. I don't regret the trip. It was just an adventure to go. Are there fires by you? I don't know, although it was a little smoky outside today. So there was that. So yeah, I'm gonna set goals for various pictures and so forth. What is it? This one will be a proof of life photo. So what is it? Vez from Quebec. I've just bought a piece of land, so probably my last super chat for a while. I'm officially broke. I want to see Rob. Fair. I may end up selling the land we got, and the reason why is because Mrs. Runkle and I are like, we need to build a new house. And what is it? Because, this one just flooded and might flood again. So might end up selling the land in order to free up money to build the new house. So it is what it is, but we haven't fully decided. We haven't made that call yet, but it is what it is. And at the end of the day, if we get the new house, that'll be a nice thing in any event. So, all right. We got a bunch of stuff to talk about today. And yeah, because that's the other thing is I miss talking with you guys. I've been missing making videos. The in-laws set up a place and yeah. Did I put in for draws? Yes, but I didn't really get much. Yeah. I'm the greatest architect in the whole of El Salvador. Yeah. Would you have to sell all the land or can you split it down? It wouldn't make sense to split it. So, yeah. How long have you been married? About 17, 18 years. Creeping up on 20 years. So getting there. Yeah. Runkle Erasma, are you wearing a mask during cleaning? Not a whole lot. Yeah. Proof of life of Potter's elf toy. I don't have that handy because it's not here. But the elf toy is one of the ones. So Potter's toys all got soaked. And they all got soaked in, disgusting, gross stuff. So, what is it? We had to JMR. I know the exact date. I just don't know the math in my head as to as to how many years it's been since that date. So the what do you call it? So Potter's toys all got soaked, and Mrs. Runkle went and I was like, oh man, this really sucks. And Mrs. Runkle was like, I'm going to try to save some of the toys. And I was like, I don't think we can. And she's like, nope, gonna try. So she went and took several of his favorite toys and washed them and really put in the work. And so the elf is saved. So are a bunch of the other ones. And yeah. So we've got toys for Potter. The other thing that's kind of funny is that because we're staying with the in-laws, the in-laws also have a dog. And so one of the toys that the in-laws dog has is this little pink flamingo with a squeaky thing in it. And that dog got that toy like a week before the flooding. Potter has now stolen that toy because he objects to anybody biting it enough to make it squeaky. So he took the toy away from the other dog in order to make sure that nobody would bite it and make it squeak. And he is protecting the squeaky toy because you are not allowed to make the toy squeak because then you're biting it. And that's, so it's like, you sweet, lovable moron. It's supposed to squeak, buddy. That's what it's for. That's why we get it. But nope. He's like, we're just gonna we're just gonna love the hell out of this thing. So, all right. What should we cover first? There's a whole lot of stuff to cover. And how are we doing on the goal? Because I might need to pull up the proof of life before we jump into anything. I have too many windows open. I'm going to kill some windows. Windows, go away. There we go. I think I've killed a whole bunch of windows. I'm going to kill a whole bunch more there. And there we go. Okay, we're at 8 out of 10. So I'm going to read the super chats and then I will see there. I have a general question. Why are lawyers so mean on Reddit? I mean, not all of them are. I don't, depends on where you asked. So will I be covering the Clancy case? Maybe. I am behind on stuff. So one of the things I really need to do is I need to go and I need to like watch the Tyler Robinson stuff. So Vez from Quebec says the old boom is too wet. Somebody was like, the boom is too long. And I'm like, it is. So Hawk Banana No, thank you for 20 gifted memberships. Much appreciated. Aqua says, so sorry about the flood. Yeah, it's been exciting. Red Pen, Restoration Fund contribution. Thank you. Sandy, thank you for the 10 gifted memberships. Suzanne D says, insurance is such a pain these days. I'm so sorry. It is an adventure. The other thing I will say is I really like, what is it? I really like that Mrs. Runkle is a huge hero on all of this. And the reason why I say that is that with all of this stress, it could be really easy for her to add to the stress, right? To freak out and, you know, all of this stuff. And instead, she's just like, no, we got stuff to do. Let's go do it. And that is amazing. I am, yeah, just, it is awesome. All right. Did my proof of life email go through? Where did that arrive? Where is that? Why is that not in my... Yeah. All right, I gotta send those things again, I guess. Oh, and a Zora thing, because we like Zoras. Share to email to me. Send. Trying to get them off my phone so I can share them here. Oh, that's interesting. Let's see. Come on. Come on. Got to... Oh, and thank you, Kim, or KPT. And thank you as well, Brenda Jane. So much appreciated. I see those just came in via PayPal. Let's see. Why is this not sending? I need to share the proof of life. Why is email so annoying? Okay. We'll read more super chats while I wait for that to arrive. Pearl Snap says, welcome back. You were missed. Thank you. Were you able to salvage some of the dog toys, says Aqua? Yes, it was a bit of a production, but we were. Patricia says, for the photo, thank you. Glamasu has been thinking of you, sending lots of support. Hugs to the pups. As a former insurance compliance officer, happy to help where I can. I mean, if they sent us the policy limits, there's not a whole lot to do there, I don't think. Let's see. Oh, somebody says check my signal. Elf Wiggins says I'll pay a bribe to support flood relief. Thank you so much. The flood relief is a whole adventure. Oh, excellent. Thank you, Sandy. I will. I can pull that one up. Let's see. All right, so we got a proof of life photo here, and I look stupid in it, but that is kind of how these things work. Whoop. Stop screen, share screen, different screen. Embiggen. So I had some fun with this on Twitter because so I posted a thing and I got everybody wondering what was going on there because so what I did is I took this picture and then I ran it through I ran it through like an AI thing. I forget which one I used. And I was like, make it look like I photoshopped in the make it look like I photoshopped in the other person. Now, somebody says you are taller. No. I don't know if you could tell from this. Okay, we're doing feet pics, I guess. I don't know if you could tell from this. I am higher up than Rob. I am not taller than Rob. So that is an important yeah. All right. What is it? I had flooded basement a few years ago. Insurance didn't cover it. Said it was seepage. There was so much rain, the window well filled up, then broke. Oh, geez. Vrila's Hobby Channel Flood Relief Fund. Thank you. Overslept, but catching up. Good to have you here, Celebrial. Lindsay Metcalf. Hopefully some of Potter's stuffies were salvageable. We did save some, including the elf. Sandy 136. It's because you teased us with a picture of AI Rob. Yes, here's the real picture there. So what I'm hearing is you temporarily had an inside pool. Geek butts. That's how we cope with flooding here. Yes, that is the thing. Honk Banana, no, this is BS. Usually the ransomer shows proof of life before we have to pay the ransom. Now show us Rob. There we go. Bez from Quebec just bought a piece of land, so probably my last super chat for a while. I'm officially broke. I want to see Rob. There is a Rob. Jane Doe says, good luck. Thank you. Proof of life for Potter's elf toy. I'll have to get that for you. I don't have it here. Susan says, a small donation toward the flood damage. Thank you. It's appreciated. Lindsay Metcalf, silly chat asking a lawyer to math. I demand proof of life. Thank you. Mrs. Runkle, heart. Well done, ma'am. She is awesome. Mispronounced name. Thank you so much. Sandy says, we need real proof of life. Thank you so much. Kathy Heck, please cover CA versus crappy childhood fairy. Her name is Anna Runkle, and she helps with CPSD and coaching. Okay, I assume no relation, but I'll have to check that out. I'll have to remember to check that out. But did the ouchie stick survive? The ouchie stick has survived, although it is broken because of other things. Honk Banana, no, to be fair, tonight's boom really should have just fizzled wetly. No. Thanks for the proof of life pick of Rob. Yes, we had fun with it. And yes. Also, roll. Rolling along still says for the puppies and anything else. Thank you so much. The puppies are actually doing great. The puppies are tough. They are surviving just fine, which is nice. So, all right. Now I've got to do a video file here. So let's see. Where'd that go? All right. How do I know when that picture was taken? Oh, God. It is recent. It is recent. Will Rob come back? Yes, Rob is just sort of dealing with some life stuff. All right. So here we go. Let's start off with the Turtleboy thing. So here we go.
For Mr. Carney and Mark Federer. Good morning.
Good morning, Mr. Federer.
Hello, Your Honor. Timothy Grado for Aiden Carney.
Okay, why is that not working?
Client Aiden Carney.
There we go.
Mr. Grado, good morning, Mr. Carney. Okay, folks, we have a number of things to do today. Not a lot of time, so let's jump right in. I want to remind, though, those of us who are joining us by Zoom, if you haven't registered for the SJC,
I hope you guys can hear that. And I hope, oh, you guys are probably getting a super awful echo. Let me fix that. Okay, hopefully the echo will be fixed. New goal. New goal is going to be for a picture of Mount Garbage. Mount Garbage picture. There we go.
1.19, rebroadcast is inappropriate and unlawful. So,
Your Honor, I'm happy to go through in the order that you set forth in your order.
Sure.
I have had some discussions with counsel on some of the issues, and I don't know if you prefer to hear that first.
that's on the discovery issue.
Yes.
All right, we'll come to that last. If you've reached a resolution, that's fantastic, but let's deal with the motion to dismiss first. Mr. Bedrow, your motion, I'll hear you. You might want to concentrate on a couple of things to start with.
Okay, so court is real quiet. Okay. Let me try to fix that as fast as I can. So what this is this is a motion to dismiss. Mr. Betterow is asking the court to throw out the case against his client. And his client, of course, is Aiden Carney, who is Turtleboy. So he is here to ask the court to throw everything out. And of course, courts are reluctant to do that. And there is no closed captioning available, unfortunately, on this. But I am going to see if I can juice the audio and then resave it. So we're going to try to fix that here as best we can. So audio. All right, that might help. So let me just, it's just going to take a second here while I resave it because I've got this on my computer. So here we go, resaving. Yes, I will probably do that once it comes out. And yeah. All right. Just see. Yeah, sadly there's no closed captioning available. It just there isn't. We don't have that. Let's see what else is on the go here. This is going to take just a brief moment while we get this done. Okay, I'll toss some coins in for a chance to see Mount Garbage. Mount Garbage is the grand adventure of just how much crap I've pulled out of this. So yeah, it's a real project. Yeah, let's see. Is this Judge Doolin? I can't remember if it is or yeah. Will you go over the CCFR's factum? Not this time, not on this stream, but I do plan to do a video going over the CCFR factum, going over some of the other stuff. Yeah. What is it? I just came on and had a jump scare with Runkle's hair. Why does your hair look like you stuck your finger in a live socket? Sorry to hear about your flooded basement. I mean, let me just embiggen for a second. So the house is a little interesting mix of like super dehydrated and super not. Oh, did Rob's tie survive the flood? Proof of life on Rob's tie. Rob's tie has survived the flood. So, yeah. What is it? Just make sure you don't accidentally dox yourself with pics of damaged stuff that might have an address on it or something. I made that mistake once. I don't think it has anything like that. It's mostly carpet and drywall and, you know, that kind of thing. So I don't think there's anything. I'm just looking at it now to see if there's anything that doxes me. What is it? There is a what is it? I guess there's a box of Brussels sprouts. It was just something that I got to carry stuff home in, but I don't see anything doxing. Of course, now that I say that, somebody's going to be like, I have found your, you know, hidden secrets. And I'm going to be like, oh, man, damn it. I'm not sure what hidden secrets I might have, but yeah. What is it? Including your house in the background. It shows the fence in the background. So biggest risk is boxes with shipping labels. I don't think that there's anything like that. Brussels sprouts. So they banned bags here in Edmonton. And so instead we a lot of the like grocery stores, you take your stuff out in like a cardboard, you know, vegetable box or whatever. I had a bed and I slept. I mean, I didn't get enough sleep. So, you know, I got some sleep, just not enough. All right, how are we doing? 5 minutes left on this render job for all of that. Gerald Manning, thank you. That is incredibly generous. Gerald Manning says, sorry to hear about the flood. Thank you. Very generous, and it's going to be an adventure. It's going to be a, yeah. So, I mean, what is it? Did I have to cancel any court? No, but I did have to get an agent for some court appearances. And so that was fun. I had to. So an agent is when you hire another lawyer to appear in terms of, and they appear and act as your agent. So they act basically as you. So they are you for the, what do you call it? You know, for the purposes of that appearance. So basically, I just had to get a person to step in and act as me in order to ask the court for an adjournment on the basis of my basement is still flooded. And yeah, it's an adventure, but I didn't miss any court. There was not any, you know, but there are some things I'm behind on that I need to get off my butt and do. So, yeah. You haven't told us what you're drinking. Camera. Eyes front. Red Bull. I got a Red Bull. So contains sufficient caffeine to keep me coherent. All right. And yeah, that flavor is actually one of my favorites of their fate or of their sort of temporary flavors. So I think it's pretty good. What is it? I think I will pour myself a rum though. It feels like a rum day. This is from the Just Distillery Incorporated. They make some really good stuff, and they gave me some of this. So it's a me, Tony P says, if you're behind on work, just have Chat GPT do the work for you. Yeah, that's not a recipe for a good time. Sancha. I think that's the right way to pronounce that. I'm always, every time I try, people are like, no, that's not correct. So it's like, all right. Where do you throw the empty cans? I have a bin for cans right behind me. The bin has a bag. The bag goes out when it gets full. So that's yeah. It just helps me manage them because I drink a ton of Coke. So yeah. All right. The great thing about using ChatGPT to lawyer is the break from being a lawyer when you get caught. Yeah, you'd have to hope on that. Aqua says, I'd say you've earned a belt of rum or two. The other thing that is really annoying me, is that I can't find good grapefruit juice. And the reason why this annoys me is because when I was in Chicago, I managed to I say I managed to. It was actually the Matas that got this for me. This you cannot find in Canada anywhere. Suze. It's a French thing. It's hard to find. But there's a place in Chicago that does like unusual and rare alcohols. But the problem is that the drink that this is really good in is you take this and you mix it with grapefruit juice. Now, the problem is that the grapefruit juice that this goes well in is like actually genuinely bitter grapefruit juice. And you cannot find genuinely bitter grapefruit juice anymore. You find like this super sugary, like ruby red shit. And I'm like, no, I want grapefruit juice that's going to punch me in the junk and be super bitter. And it's like, no, people don't like that. I'm like, I like that. And they're like, yeah, but are you people? And I'm like, well, I thought I was. So, but you can't find the good grapefruit juice. And the other problem is you can't even find the good grapefruits because you want to find the actual bitter grapefruits and they breed the really super sweet grapefruits. And it annoys the heck out of me. So I want actually proper bitter grapefruit. Oh, I see we hit the goal before the render was done. So let me open up an image here to show you guys the now this is one of the piles now because we now have another pile, but let's see, where is the let's see, can I add this? Oh, I gotta remove this. I gotta move that entirely. Okay, can I add this now? All right. So this is what's going on in my backyard. So you can see all of the carpet, you can see the drywall, you can see like all the stuff. This brown padding down at the bottom is from a couch that is wrecked and has to go. So yeah, it is awful. All of this. So yay. All right. Now I think I've got a new I think I've got the video or the sound problem fixed. I'm gonna have to rent a dumpster. Yes. That is gonna be it's gonna be one of the things I gotta do. So all right, let's do this.
Before Mr. Carney, Mark Better. Good morning.
Good morning, Mr. Better.
Okay, the audio is much better now. I think that I think we've got much better audio. So yeah.
Hello, Your Honor. Timothy Grado, 48 in Kearney. To my left is our client, Aiden Kearney.
Good morning, Mr. Better. Good morning, Mr. Carney. Okay, folks, we have a number of things to do today. Not a lot of time, so let's jump right in. I want to remind, though, those of us who are joining us by Zoom, if you haven't registered for the SJC, for the SJC rule 1.19, rebroadcast is inappropriate and unlawful. So,
Your Honor, I'm happy to go through in the order that you set forth in your order.
Sure.
I have had some discussions with counsel.
And I missed that. So the court is saying rebroadcast is not appropriate. So we're going to cancel that. Because I assumed that this video clip that everybody was using was per the court's allowing it. But if the court is not allowing it, I'm not going there. So I got to apologize. I will instead summarize what went down because if now that I have the better audio and can actually hear the court saying, hey, this is not for rebroadcast, well, then we're not going to rebroadcast it. I couldn't hear that on the original audio. Court is talking about Zoom. Is it allowed to play a recording? Let me see. Oh, it was only for the Zoom. Okay.
On some of the issues, and I don't know if you prefer to hear that first.
that's on the discovery issue.
Yes.
All right, we'll come to that.
Okay, then I'm missing. So, okay, we've got the video. All right. I'm misunderstanding it. Apparently, this is allowed to be rebroadcast. The Zoom isn't. So, all right.
Last, if you reached a resolution, that's fantastic. But let's deal with the motion to dismiss first. Mr. Bedrow, your motion, I'll hear you. You might want to concentrate on a couple of things to start with. Number one, there was already a fully litigated motion to dismiss both under McCarthy and under Odell, in which Judge Doolin drafted a 6 or 37-page decision, which is an exceptionally fulsome decision from the court, in which he found probable cause for the majority of the indictments, but dismissed all of them, including the one that seems to be at the heart of a number of these motions, that is to say, against Mr. Proctor. So the first issue is this: under Rule 13, under Commonwealth versus De Los Santos, which I'm sure you've reviewed, which is 492 Mass 242, 2023 case. If the matter was not raised, it's considered waived. So tell me why. I understand that the issues with Ms. Peters may have been disclosed post that hearing, at least to some extent. Tell me why the other issues aren't waived under De Los Santos and Rule 13.
Was there another issue you wanted me to focus on as well?
No, that's to start. Then we'll get to the substance of it.
Thank you, Your Honor. Judge, it is true that many of these issues existed in grand jury transcript and motions that were ruled upon by Judge Doolin. That is correct. And Rule 13 does state what it states, but there is case law which also states that the court does have the power to reconsider or reevaluate issues which were not brought to the court's attention. Now, in this particular case, there's no question that issues that related to the wiretapping, the uncharged wiretapping, for example, could have been raised. As the issues related to some of the videos in this case, the name changes, the court should be aware that for whatever reason, that snuck by everybody, including Judge Doolin, including Mr. Cosgrove and some of his filings, and as soon as that was picked up, that is something that we put into writing and addressed right away. The reality is, the grand jury in this case was not proper. I mean, I think, and I'll get to that in a minute after answering Your Honor's question about the waiver issue, but in terms of the form over substance.
It's not really form over substance. It's substantive. Rule 13 is substantive. Del Santo is substantive.
So basically what they're doing at this point is they're just doing the basic stuff of, let's figure out what we're doing here. Like, you know, Mr. Betterow, here's the arguments I want to hear. So they're talking about, like, is this a substantive aspect? This is all of these things. Doing a Galapagos dive trip next year, what was your favorite thing to do, see when you were there? If you can, snorkel, dive, like all of those things, that is amazing. Because I got to see penguins. I got to see a hammerhead shark. I got to see turtles. I got to see sea lions. I almost crashed into a sea lion. That was really amazing. Like, the sea lion almost crashed right into me. It wasn't looking where it was going, and it just sailed right up to me, and like my hands came up of like, oh shit. And then it saw me and just ducked. And so, I mean, the underwater stuff was really awesome. But everything was amazing. Also, I got to roll this. Brentwood Cheeks is not into PayPal, but I hope what's left after the overlords take their share helps with dumpster rental and importing some grapefruit juice that punches you in the junk. I am not I looked on Amazon. People were saying Amazon, it doesn't have it, at least here in Canada. So, yeah. Yeah, Hammerhead, awesome. It really is. So, all right.
And there's a reason for that. And the Commonwealth and their opposition is pointed it out. So you can't keep retailing the same ground over and over and over. It's not going to get move forward. So it's not just form over substance. So you're going to give me a little bit more than that.
Well, Haskell permits it, Judge.
It does, at the court's discretion.
Right.
But you got to have a reason.
Absolutely, there is discretion of the court to ultimately decide what should be done and what shouldn't. But where the court sees prejudice, the court respectfully should act. Now, again, with the videos that were mislabeled, the Commonwealth shouldn't benefit from what is clearly deceptive conduct in terms of renaming items that, again, nobody saw. Judge Doolin himself referred to the names by their improper name during his ruling.
Which presumes that Judge Doolin was aware of those names and didn't find them to be of any substance because he watched the actual videos.
I don't know. Well, the actual videos that were presented to the grand jury, Your Honor, were 40-second snippets of hours-long video, which were not grand jury exhibits. So, respectfully, there's no way that Judge Doolin could have watched those videos because Mr. Mello and...
You watched the clips, no doubt.
Yes, but the clips are tiny segments of larger videos that, again, when we get to the real meat of what I want to discuss with the court, would show the full context on the critical issue in this case, which is only one, and that's Mr. Carney's intent. That's the only issue that was really before the grand jury, and none of that was seen in Judge Doolin's opinion, because none of that was before...
Because it wasn't raised.
Well, it wasn't raised, but it wasn't known by anyone. Now, again, could it have been? Yes, but the court has the discretion.
But it was known, because Judge Doolin referred to it by the titles that you think are inflammatory.
Yes, those are the names that he was provided by the Commonwealth that were changed. Those were the improper names.
Okay, so the issue that is going on here is with regards to the grand jury and whether the grand jury was properly given a proper situation for dealing with this, because there's rules for how you conduct a grand jury. The grand jury is supposed to have access to all of the evidence, but also you're supposed to not take efforts to taint the grand jury. And taint is a wonderful word because it sounds dirty, and it is kind of dirty. Because, yeah. So the issue that is being raised about the grand jury getting tainted here, yes, I know, is that the files that were given to them for showing various video clips of Turtleboy were named things that were not the original names of the video clips. And they were renamed in ways that make it look like the video clips were titled things that are sort of confession-y, right? So instead of like, you know, it would be like if you took this video, which is Monday Law of Fun, brackets, Flood Day, Richins, Tates arrested, Turtleboy, Frogan, and you instead titled it like, you know, Runkle kicks a puppy or something like that, right? So that's a problem. Now, who named them? Well, the prosecution is also responsible for that. Doesn't matter who named them, in my view. Ultimately, it's that they presented it to the jury and it was wrong. So
names that the Commonwealth knew in advance were not the proper names and were changed. And ultimately, Your Honor, as a matter of discretion, there's no prejudice to the Commonwealth here by having this. I suspect this argument, which is a fair argument to make, is their primary argument because they don't want to talk about what actually occurred in the grand jury. And the fact of the matter is, everybody sees it, everybody knows what it is, and it ought to be addressed. If there's no prejudice to the Commonwealth, the court should hear it. No indictment should be tolerated when it is rife with misleading evidence, distorted evidence, statements of prosecutors and police witnesses saying, in my opinion, it was this man's intent to commit witness intimidation. That's outrageous behavior in front of a grand jury. And when you get down to brass tacks in this case, that's all that this is about. They misled the grand jury on the only issue that matters, which is whether Mr. Carney's intent was to commit witness intimidation or not. The conduct at issue is open and shut. It's the videos, not the videos that were submitted into the grand jury. Those are tiny snippets. The conduct and the context of Mr. Carney's intent are contained in the actual videos. And what you have...
So here's the thing that they're sort of talking about here. The prosecutor is allowed to show an excerpt of a video clip, right? Like, let's say I'm being charged in the US, they're doing a grand jury, and they just want to use this moment. And like they're saying, Runkle held up a bottle and it said Sue's on it, and that's the evidence we want, right? They're allowed to use that clip. However, the wrinkle on that is that you have to actually Frogan jump scare. Was there a thing of Frogan? Oh well. They have to have the whole video available, and the grand jury can say, you know what, we want to see the whole thing. We want to see the whole damn video, right? And this is important because imagine there's a self-defense case or something like that. And you've got, you know, this guy pulls his gun and shoots a dude. Okay. But what happens before that? What happens after that? The grand jury might be like, we want to see those things. So
at this point, it's very similar to Odell itself. In essence, you have prosecutors cherry picking 30 seconds they like out of a 2-hour video and saying this proves his intent was to intimidate witnesses, but not letting the grand jury have access to the other 2 hours, which show him saying, I want to bring awareness to a miscarriage of justice involving Karen Reed. I'm petitioning the government to address that. I believe that these police officers are corrupt. We're doing this to bring justice for these people. The grand jury had a right to that. And the best example of this, Your Honor, to get a full picture of what you're dealing with is all of the picketing accounts in this case are from this so-called rolling rally. That entire video, the whole rally was recorded, video recorded by Mr. Carney, literally the crime, if you will. They didn't introduce that video, but what they did do was admit 58 seconds of the rolling rally, which the honest name of that video on YouTube was Canton, the rolling rally, Justice for Karen Reed and John O'Keefe. They took 58 seconds of that video. They introduced it as, the title of that video is Don't Feel Sorry for the O'Keefes. That's not evidence, but if you look at the grand jury testimony and the transcript, the way Mello and Tully did this is Tully said, the name of the video is Don't Feel Sorry for the O'Keefes. It's contained in a folder literally titled Intent. Literally. And he did that approximately.
Now, to me, the judge goes and handles this in a very different way than I would. Because to me, this is pretty obviously improper. And the judge is like, I don't know if this is improper. I don't know. To me, I'd be like, yeah, this is improper. Let's talk about what the proper remedy should be. You know, because I don't know if the remedy is throw it out, right? I don't know if we get there. Betterow would have to convince me on that one. And Betterow's doing a great job here, although the judge is skeptical. This hearing doesn't go super well for Aidan Carney, and I don't think that the judge is going to throw things out. I think Betterow's doing a great job of arguing his case, but I think the judge is kind of missing the point.
30 times throughout this proceeding, told the grand jury, this is proof of his intent. They literally asked questions and answers that talked about intent. They played 30 to 50 seconds of this video where he literally says, don't feel bad for the O'Keefes, but yet don't present the video of the crime. Why? What prosecutor?
But their allegation is that he's the crime.
Your Honor, again, it goes to Odell, literally. They can believe anything they want. They can allege anything they want.
But they're not alleging that the rest of the rally was intimidation. They're alleging those clips.
Of course.
Intimidation.
Right, but Your Honor, when they present it to the grand jury, it's tantamount to what happened in Odell with the police report, where we decide we like sentence 1 because we think it proves his intent, but we don't like sentences 2, 3, 4, and 5, so we're just going to keep that from the grand jury. In Odell, that was deemed to have impaired the integrity of...
But police report and a video are very different things. We often encounter situations at the grand jury where they have hours and hours of videotape, but they only play certain clips. But
they didn't tell the grand jury it's available for you. The point is, they told the grand jury the name of the video is... jury influence is another one, which was actually titled Protesting Michael Morrissey. Big difference. A video that was 5 days after D.A. Morrissey made a statement to the press, which was improper. He gives a 2-hour video and says, I'm trying to bring awareness, trying to do this and do that, and this is in August of 2023, well before a trial. And says, absolutely, I want to influence the public and the jury pool. And they take that little snippet. They may have a theory that enables them to say, we believe that's proof of his intent. That's fine. What's not permissible, though, is to rig it in the following way. To say, literally, Your Honor, I can read to you, there's a literal question and answer, which is very important. For example, on December 19th, question from Mello to Tully. before he plays all of these videos, which are misnamed, cherry-picked, do you have any knowledge of incidents which you feel are intimidating of a witness with respect to any particular witness? I do. Question, those are on video. Answer, they are. Play those for the grand jury. So now we've just told the grand jury, I think his intent was to intimidate witnesses. Then what Tully does again and again, through direct intentional questioning of Mello, it's not volunteer, is to say that these videos are named inaccurately, and they're in the memo. You've seen them, page 62 and 63 of the motion, all the times that they did this. They play the snippet, and then when it's over, they tell, or before they do it, they tell the grand jury, these are from a folder marked intent. He didn't do that.
So, Mr. Mayor, you have to give the grand jury some credit.
This part, I'm just going to back this up a little bit because this part made me freaking scream. I was shouting at my screen when I was watching this earlier. Shouting. Straight up shouting.
They tell, or before they do it, they tell the grand jury, these are from a folder marked intent. He didn't do that.
So, Mr. Mayor, you have to give the grand jury some credit. The grand jury understands that a defendant is not going to create a folder which says intent. They had to know the prosecution created it.
But that's my...
No, we don't have to give them credit for that because it is entirely possible that somebody created a folder called intent. It is entirely... There have been people who have been arrested with a folder titled murder plans that contain the plans for the murder. And so the jury cannot assume that the folder titled murder plans was not titled by the person, right? How does the jury know who titled this? He's like, we got to assume the jury... No! Why should the jury assume that the prosecution changed it? Fuck! Like, yes, we covered this like a few weeks ago. Definitely not a bag full of drugs was printed on the bag that was full of drugs, right? How do we assume that the, like, I had a client, he was accused of bad pictures, possession of bad pictures. And you know what they were stored in as a folder on his computer? He had a folder on his computer that was titled Child. So, you know, how is the jury, you know, should the jury assume that that was titled by the prosecution when it wasn't? Like, yeah, and in case you're wondering, that case was largely about how much the guy got punished, not whether the guy got punished. So, yeah.
Right,
but give the grand jury some credit. They understand that.
Your Honor.
No, Judge, the jury doesn't know who labeled it. Judge, I'm not giving the grand jury any credit on this because I also can't give you any credit on figuring out this issue. So, yeah.
The point is, respectfully, when a police officer tells the grand jury, in my opinion, this man's intent was this. I have a folder with proof of his intent. It came from that folder. I'm going to tell you a false name of the video that I renamed or some third party working with him renamed, whichever the case may be. And then you don't tell the grand jury that this was renamed by us, put in this folder by us. I'm playing you 30 seconds, but I'm not going to give you the rest of the video. And I would refer the court, this case is cited in the memo of law that went with the motion, Bleakney, the appeals court case, not the SJC, the lower appeals court, where they cherry-picked a portion of a statement of a defendant, left the full flash drive in front of the grand jury, but never alerted them to the contents of it. And in that case, the appeals court found it impaired the integrity by hiding the ball. Here,
If you're going to go there, Mr. Better, if you're going to go there, then you got to talk to me about Shaquille Brown, which is the SJC, in which the prosecutor dumped in at least 100 pages of prison records, in which the prosecutor dropped in telephone logs, all of which had never been looked at or never been read. And the SJC said, well, it wasn't so good, but that's okay because it didn't change the analysis of the evidence, which takes us back. And this is the
You sort of have this feeling already of how this is going to go. Like this, and I saw people on Twitter being like, Bettero did a bad job because the judge is giving him shit. And I'm like, Bettero did a good job with a judge who was giving him shit. And, you know, sometimes you can have a really good argument and you can walk into court with a really good argument and you can still get hammered, right? You can still get flattened by that. And, you know, so this is part of, like, everybody's like, oh, I want to be a lawyer. Do you, though? Because sometimes being a lawyer is like this. You walk in, you're like, I think I've got a great argument, and the court is like, yeah, we're just going to hammer you on that because we can. So, you know, you got to think carefully about, you know, how much you really want to be a lawyer, because sometimes being a lawyer is about this. And I mean, I don't know. I was very annoyed by this hearing, and that isn't to say that I necessarily think that they should have won this one. But there's a difference between whether they should have won or whether they should, like, because at the end of the day, this one, I'm like, I don't know if they necessarily should have won, but I hate the way the court is handling it, right? And I really hate that the, you know, I just, yeah, I don't like how this is going, is I guess the long and short of it.
yes, sir.
So now, this is the difficulty that you have. See, Barney, this is why Del Santos does matter, and it is substantive, okay? This is why Rule 13 is substantive, because you already had a very thoughtful, all right, a bulwark, if you will, from a judge, all right? A very thoughtful judge who examined in detail the entirety of the grand jury, found it to be free from prejudice, and more importantly, found that the evidence was substantial enough to issue an indictment. So that brings us back to the court's analysis in Shaquille Brown, which I'll give you the side if you like.
I have
490, 171, and I'm very familiar with that case. All right? In that case, the court finds clearly they shouldn't have done any of those things, but finds it didn't impair the integrity of the grand jury, which does, and this is why De Los Santos is substantive.
So what the judge is basically saying here is, look, maybe this wasn't great, but at the end of the day, your client was going to get indicted at the grand jury, so who gives a fuck? It's kind of the vibe.
Because Judge Doolin's already made that determination. So you got to get around that.
I'm happy to, Your Honor. The difference with Shaquille Brown and Judge Doolin's decision and why it matters here is context is everything in terms of his intent. Oh, he is
But in Brown, they're trying to show joint venture, and they dump in prison records they haven't even read.
Judge, I'm bringing it to this case, okay?
But this is the SJC telling us.
I understand that, but the facts here matter, and the context matters, and just because the prosecution has, you know, a one-sentence explanation of what they say, and a grand jury ultimately determined was proof of intent after they were told what his intent was by the prosecutor, by all the reasons that we spoke about earlier, context is everything. If there is a long statement that is talking about protesting and bringing awareness and making jokes and all kinds of things, and there's a comment in there that I like that comment, just give the grand jury the whole thing. The role of the grand jury is fact finder. The problem in this case is that Mello and Tully decided to be prosecutor, detective, and fact finder.
Grand jury's not really fact finder. Grand jury's more of a gatekeeper. But go on.
But they have to find, Judge, respectfully, they're not. They have to find the facts to support an indictment. And in this case, they literally did. But they were misled, and context matters. A grand jury is entitled not to everything in the world. It's clearly not a trial jury. We all understand that. But when you do it, you have to do it fairly.
So the grand jury isn't entitled to everything in the world, and they're not a trial jury because the grand jury only has to say, is there enough to get over this hurdle, right? Is there enough to get over the hurdle of should this go to, a full trial? Also, Aqua says, okay, really going now. Thank you for joining us, Aqua. It was good to see you. Was it, I had a flood in my apartment. Yeah, 10 days of 2 industrial blowers and dehumidifiers, loud, so little sleep on the couch. His bedroom took the worst. We are not even able to sleep in the house at the moment. So, yeah. Also, we hit a goal. So I've got to, I got to show you guys a little video clip here. Hopefully this will work. All right, so that video clip is too large for that way to do it. Let's try to do it this way. We're just gonna... I gotta try to show you guys a Zora. So, video file. Hopefully this will work. Because I owe you guys a Zora. Video is kind of a little choppy here. I think the bit I wanted to capture is right at the end. Oh. All right. Is this video... Oh, this video is not very good. It's kind of choppy. There you go. You can sort of see it. I don't know. Hopefully you guys can see it a little bit better than I can. I don't think that video is very good. I'm going to have to figure out what's wrong with it. But Zora was sitting there laying out all sleeping and, sprawled out, and her legs were going twitchy, twitchy, twitchy. She was running after something in her sleep. So...
Finger on the scales with evidence of his intent. in terms of what they told the grand jury, what file it was in, the length of the video, the full context of the video, the uncharged crimes. The last piece of evidence in this case that they put in the grand jury was an uncharged crime of, again, the rolling rally video, which they didn't see fit to give the grand jury, which makes no sense. If anyone's prosecuted these cases and put in cases in the grand jury, that makes no sense. That's the crime. Give it to them. But what they did was they tried to suggest that he was harassing and intimidating the O'Keefe. So we're not even charged victims in this case. That's how they finished the grand jury. That is clearly a design to prejudice, to smear. They put in evidence of an uncharged wiretapping and read the statute that said this is punishable by 5 years and never gave a curative instruction, never withdrew that charge. De Los Santos or not, Your Honor, the question is, at what point do we not avert our eyes to what they did? They need to do it fairly.
But the judge has already looked at that.
But he didn't see that, Judge. If you look at Judge Doolin's decision, none of that is addressed because he, like everyone else, was misled. Moreover, Judge, I am focused on the grand jury. I'm going to answer the questions that obviously you're focused on. There was a second component to the motion for extreme government misconduct, and there's no reason why.
Well, I'll listen to you on the Peters stuff. I mean, I think if Peters wasn't known to you, I think that's fair to discuss.
Well, it wasn't. I mean, the whole point, but before I get to the merits of that motion would have been made anyway. So that, because we can't make a motion based on evidence of which we're unaware, obviously. And at that point, if you're making a motion to dismiss for extreme government misconduct, there's no reason why the court should not consider as a facet of the misconduct that occurred in this case what occurred in the grand jury before. Now, as far as the Peters stuff, which I don't want to beat to death, and most of it is in the papers, the point is, all of that evidence should have been disclosed in early 2024, which was we're closing the deadline for discovery. That material didn't come anywhere near that timeline. It came in July of 2025 after numerous specific, very specific Brady demands and Discovery Rule 14 demands. They could not have been more specific.
So let me understand, what is the basis that you're asking to dismiss? Is it for the discovery violations or for the substantive violations?
Well, it's for everything. On the second component of the motion, the indictments ought to be dismissed based on the impairment of the integrity of the grand jury proceeding, full stop. As far as the second component, based upon the lack of discovery, that prejudiced us from filing a full-throated motion the first time. The court should consider that in even hearing the grand jury component of it, but in
full-throated. Yeah, this is, you can tell the judge is not really wanting to hear this because he's like, you already had a motion to dismiss. And Bettero's like, look, we didn't have all of this stuff that we have now. We were kind of having to do the best we could on this motion to dismiss, but yeah.
Any event, if the court is wondering why discovery was ordered to be completed in early 2024 and all these demands were made before, during, and after that time period, and stuff that is responsive is showing up in July of 2025 that we turn out to learn was in the possession of every single prosecutor on these cases in December of 2024, which is before the motion was filed in front of Judge Doolin. What is going on?
I consider these to be two separate categories. That's why I started with the issue of Peters maybe something which is outside Rule 13 of the De Los Santos analysis. Just want to give you an open field to discuss that.
Okay. Excuse me, Judge. The evidence that exists or no longer exists from the third party that the court mentioned is extremely prejudicial to the defense. there is a strong argument that could be put forth if there were to be a trial in this case, that this investigation was biased, it was shoddy, and that involves any number of things, one of which includes, from our perspective, which is a shockingly close relationship between a private civilian, Peter, who you mentioned, who has a hatred of Mr. Carney that is beyond adjectives that I could even provide this court with. Not only
So, Kate Peters, also known as Masshole Mafia. That is a whole thing. Yeah, she has been involving herself in this case in a way that quite possibly has contaminated it in ways that are not, yeah. So, not fixable, I guess, is the way to put it. All right.
only that, this is a witness who has falsified evidence against him. Literally, this is not in dispute, it's in the motion. Has forged court filings to try to screw him in part of their fighting during their lives. Has attacked witnesses for the Commonwealth, Alberts, and tried to get him to say bad things about them when she in fact detained them. And this person was basically holding Mr. Mello's hand. These are the messages that we got, amongst other things, telling him what to do. And when we got that affidavit from Tully, oh, well, I didn't open or click on any of these links. That's a problem for one reason, because they were in their possession, custody, and control, and ought to have been turned over. And what was contained, we don't know. But there has to be under Neal a reasonable basis to believe there might be something useful. And the reasonable basis you have is that the person who provided it to Tully that he claims he never opened has committed forgery, fraud, deception, and crimes against him. She's a dishonest person who is working hand in hand with the prosecutors in this case. Now,
You would think that there might eventually be a chance that she gets in some trouble on this. I don't know. So
Tully says, I never opened it, and now the links are gone, and we were told in filings, it's been dismissed, it's been deleted by a third party, which presumably is Peter, and what are we supposed to do in now finding the evidence to support that defense? Just assume it's nothing helpful? Why would we assume that when this woman is bent on destroying him at Jit's Farm?
That he never opened them.
What's that?
Isn't the shoddy work that he never opened them?
That's amongst other things, but I said to you, Tully said that. That's not what Mello did. The emails that we got too late in the process literally show Mello and Peter talking, and he's asking her help. How do I open this? And Mello says, gee, thanks. He literally opened it. Opened what? Where is it? Tully says, I never opened it. It's deleted. Mello, very noticeably, never submitted. In all the time the prosecution had to respond to the motion, and if the court remembers, they got many graces and deadline extensions to file, never submitted a sworn statement explaining any of this. What we got instead was a hearsay statement where Mr. Cosgrove, and I say this with due respect to Mr. Cosgrove, was essentially cosplaying as Mello, saying, this is...
by the way, anytime you start a sentence with due respect to, and then you are talking about the other counsel, what the lawyer means is that the due respect is very little. With all due respect to my, to my friend, you mean, it's a way of saying, fuck this guy.
What it would be, that's not evidence in response. What was required is something from Mello under oath, and we've never gotten that, and that's very important too, Your Honor. One of the things that we ask for in the motion is, as an alternative, a hearing, okay? If this was intentional, the court should factor that in. Now, how can the court make a finding whether this was intentional or not without hearing from Mello, Tully, Peter, anyone else who may or may not be involved in this?
How does this affect the grand jury presentation?
Well, Peter,
I just want to see the argument. I'm not,
as far as the grand jury goes, it's either Tully or Peter who renamed these files. Now, Tully knew the full name of the files.
but according to Tully, he doesn't open it. So I'm just trying to, you may have a separate argument. I'm not saying you don't, okay, as to what the relationship between Mello and Peter was or was not. I'm just trying to make sure I understand your argument. Is this part of the Odell, or is this some separate motion?
Well, on some level, it's a hybrid. I mean, there's clearly the Odell component.
I can understand what that hybrid is,
Right.
Council.
No,
You give me kind of a mishmash here with all sorts of stuff in it, and I'm trying to sort it out.
Judge, it's a standalone Odell motion, clearly, about impairing the integrity of grand jury proceeding. We also filed,
But how does, go on, I'm listening.
there is a second motion to dismiss for extreme and egregious government misconduct based upon.
I beats me, which is a separate motion to dismiss based on what you filed, Mr. Better.
No, Judge, it's a second point.
All right, this is the problem, what you filed. We've discussed that already. I can't discern that there's a second motion to dismiss. It looks like a big Odell.
Judge, we don't know what
The judge is
missing
giving him
evidence
so much
we didn't
pushback.
get. And the argument that was put forth in Mr. Cosgrove's response to this was that if you don't know, then there's no obligation for us to turn it over because there's no reasonable possibility to conclude that it would be favorable to you. And the point is, when it's evidence that was deleted, that was reviewed by Mello, Tully claims he didn't, and it comes from a source who hates him and commits acts of fraud and forgery against him, there's a reasonable basis to believe that something wasn't right in that evidence. We don't know. And this woman was assisting these people back right before, literally days before the grand jury, explaining to Mello how to use the evidence. What is that evidence? She sent a folder titled Intent. That may we don't know, but that may very well be the clips, the change names. She'll probably deny it. She'll go online and deny it and scream and yell about it. Tully says I never looked at it. Mello is unheard of. He just disappeared in the wind. There's no sworn statement from him. These people at a minimum should be called in, take oaths, and let's get to the bottom of it.
The judge is like, I don't want to bring everybody in under oath. It's really hard to convince a judge to put the prosecution under oath. We've seen it a couple of times in trials I've covered. But in both times that we've seen it, the prosecution has walked into it. And so, like, when we saw it in the Uvalde trial, the prosecution is like, I'll get under oath. It's like, you what now? Why would you do this? And the other one we saw it in was the Rust trial, where, like, why in the hell did she get up there and put herself under oath? Like, you know, the judge is like, you don't have to do this. The defense was like, you don't have to do this. And yeah.
Need a better motion than like that. Mr. Cosmo, what do you got to tell me?
Want me to just go through it, or right? That's
All right, we'll just take this away.
okay. First, whenever I hear counsel use the word cherry-picked, what that means to me is the Commonwealth picked relevant evidence to support the charges it was looking for. I don't have any real answer. I don't deny that that was what, in this case, Mr. Kearney said, and did, and put on the air.
Well, why don't you give the whole video?
I'm sorry.
Why not give them the whole video? Okay, so go to Mr. Devereaux's point. Why not give them the whole video to watch and play them selected? Because this is often the case.
I don't know what the reasoning was at the time, Your Honor, but if you look at the chart that Mr. Devereaux includes in his motion, his affidavit rather, it runs on for about 3 pages. There's lots of videos. They tend to go about 2.5 hours each. If we give them the whole video, there is lots of other material in there that language used by Mr. Kearney, whatever, it could be construed as prejudicial. I'm sure Your Honor has already heard about reference to the O'Keefes, and the Commonwealth introduced this, and then they didn't indict him with respect to intimidation of the O'Keefes, and this was entirely inappropriate, et cetera, et cetera. I'm sure if Mr. Mellon had put in 25 whole videos, we'd be getting an argument that all kinds of prejudicial material was put in, and that the Commonwealth should have simply chosen what was relevant to the indictments. I have to say, where's the beef? I keep hearing about stuff being taken out of context.
Where's the beef? Where's the beef? That is a quote. That is a catchphrase from a commercial set that came out in 1984. So Cosgrove is pulling out the 1984 topical references. I was 4 years old when that commercial came out. Okay, Cosgrove, like, get with the times.
If only there was the context, if only the whole thing had been shown. The defense has said, the defense has read my response. It said, Your Honor, and one of the things I said was, where is it? Where's the submission to the court? These are the things that if only the grand jury had viewed them, as Your Honor is now capable of viewing them because we have submitted them, and certainly Mr. Kearney has access to his own video, it would have put things in a completely different light, and here's why. You don't have any of that. There may be some things in the entire videos that for example, Mr. Devereaux says, at one point Mr. Kearney talks about how he's going to expose corruption or something like that. Mr. Kearney could have 16 different motives. People have more than one reason for doing things, for putting something in. Some of those motives may be good motives. But those motives are irrelevant. All the Commonwealth has to prove is that one of his motives was to intimidate those witnesses. That's what's relevant. Furthermore, I think, as Your Honor alluded to, we can infer a certain degree of sophistication on the part of the grand jury. Nobody watches even the evening news and sees a snippet of a Trump press conference or something going on in the city of Boston or an excerpt from what's going on in court and leaves under the delusion that other things weren't said, other things weren't happening.
So the judge here is not engaging with Cosgrove at all. The judge is just kind of watching him. And that's because Cosgrove is not super persuasive here, but the judge has kind of already made his call, and his call is that Cosgrove's going to win. At least that's my bet. But he's just like, okay, you could talk for a while. Keep going.
Understand that the news media selected what they considered relevant and showed that. In fact, I think that's what Mr. Kearney does on his own broadcasts. People are sophisticated based on years of watching news shows and years of, at this point, watching the internet. There's nothing to stop a member of the grand jury, and for each of these witnesses, grand jurors had an opportunity to ask questions, and if you've read the grand jury transcripts, you know they did ask questions, and they certainly could have said, you know, you're only showing us a snippet here, we'd like to see the whole video. Nobody did that. Nobody.
We've been putting this on the grand jury to make sure that they get some clear presentation.
No, I don't think we're putting it on the grand jury. I'm simply pointing out that in addition to the other points I've made, the opportunity was there. Nothing was being concealed. I think the practicalities of presenting the grand jury with however many hours it would have been, 26, 46, however, these shows of Mr. Kearney's run about 2.5 hours, would be somewhat absurd, frankly. I think the Commonwealth's obligation was to show what was relevant, and that was what we did.
Tell me about the issue, your thoughts on the issue, Ms. Peters and Mr. Miller.
All right. With respect to Ms. Peters, I want to make a couple of points. One is,
It's really bad when you've got to tiptoe around Ms. Peters, and he's like, with respect to Ms. Peters, the by the way, I have a goal that is at 0 out of 10 right now for an entertaining story about beer. It is an entertaining story because it, well, you'll see. So, yeah.
Mr. Federer raises this issue of the prior federal court suit, which Ms. Peters apparently admitted to having forged a document or something of that nature. Well, Mr. Kearney would be aware of that because he was involved in it. But there is no reason why the best of prosecutors, when somebody comes to them with information, they may check out the information, which is what was done here. People once looked at the broadcast that they were pointed to, why they would go back and screen for federal court cases to see if the witness had previously been involved in a federal court case. It's not a search warrant where you're trying to establish the veracity of the informant, and maybe you do some research in that case, although I think it would.
He's saying basically she turned out to be a sack of shit, but we weren't required to look into whether she was a sack of shit, Your Honor. She's just allowed to be a sack of shit, and yeah.
Be rare that kind of research would be done. So the suggestion that the Commonwealth knew or should have known that this witness was tainted in that respect, I think is somewhat absurd.
To the best of your knowledge, did any of the Peters materials, were any of the Peters materials presented to the grand jury?
The Peters materials were presented to the grand jury in the sense that there were a couple of audio recordings that were obtained from Kate Peters, which Mr. Lieutenant Tully could not find checking independently because the theory was that Mr. Kearney had taken them down and had replaced them with different videos in which he had intercut a warning that was not actually there originally, that the conversations were being recorded. One of those...
This was the wiretap, which didn't
Yes.
happen.
Right, right. So those are the only two. The rest of them, whatever was brought to Lieutenant Tully's attention, and I can't tell you the extent to which they were brought to attention by Kate Peters, or the extent to which they were brought to attention by the victims in this case, who were obviously not happy with some of Mr. Kearney's broadcasts about them, or by both. But in every single case, Mr. Tully's representation is that he himself went to the internet, looked up the broadcast, recorded it himself, or caused it to be recorded by somebody in the office. I have to say this predates me, but I have no reason to doubt that.
I don't know why they've got the mic next to somebody typing. It's not me.
To the grand jury. And I would point out to Your Honor, to this moment, there has been no representation that any portion of the videos that the Commonwealth showed, which we presented to the grand jury as things that Mr. Kearney himself had recorded and broadcast, were not genuine. There's only been this argument that, well, they were taken out of context, if they saw something else, the jury may have thought something different.
Was the grand jury did it? I should may have noticed. The wiretap indictments, no video, or were they withdrawn?
We didn't proceed, well, on
Or did they not ask for a vote? Actually, it's a better way to put it.
well, on the Gaetani wiretap indictments, those were issued, but that complaint was
Yeah,
dismissed.
not worried about that.
So that leaves us with the Scanlon presentation. And what happened was, after the presentation was made, an issue was raised in the mind of an issue was raised with the prosecutor as to whether, in fact, a Norfolk County grand jury would have jurisdiction. Mr. Scanlon, having been, I believe, in Suffolk County, at his end of the conversation, and I believe Mr. Kearney was not in Norfolk County at the time either. So there was some thought that maybe, as I understand it, maybe Mr. Mello would ask Mr. Marcy to get himself-appointed as a special prosecutor in Suffolk County for the purpose of seeking and joining it. But it was never pursued. With that in mind, the Norfolk County grand jury just expired without anything further being done. So nobody ever went in front of the grand jury and said, this is withdrawn, but at the same time, no true bill was proposed to the grand jury relative to Mr. Scanlon.
Just never asked for a vote.
Never asked for a vote.
Any more you want to tell me?
No, I'm content to rest on my memorandum. I'm not sure I have any questions.
Mr. Bedrow, I want to back to speakers. Because I'm struggling to understand exactly what you...
So when you see that, I, like, as a lawyer, I'm like, I already know how this is going, but, you know, he's going to take it under advisement at the end of this, and I think that he's going to come back and deny it. But we'll see. I could be wrong. I've been wrong in the past.
Basis on Peter's evidence is the loss of exculpatory evidence. Yes. I don't know. You tell me, because again, motion comes in as an Odell McCarthy sort of, and then it goes on for many, many paragraphs. It never really tells me much about why this is important. So, is it an Odell, or is it a Commonwealth versus Willie loss of exculpatory evidence? I gotta know.
We don't know what Peter evidence ended up before the grand jury because nobody seems to have it. What I can tell the court is she provided a copy of a Scanlon alleged illegal.
Now, this isn't a great response because the court is like, is it under this case or is it under this case? And he's like, well, let me explain. And this is the place to either say it's this case or it's this case, or Your Honor, it's both.
Wiretap call.
Which isn't part of this indictment.
No, but to get to the point where they just said on the Scanlon evidence, we just never asked for a vote. What they never did is what every prosecutor should have done, which is instruct the grand jury, disregard them. They didn't do that. I mean, that kind of just slipped by in that exchange that was just had. You put forth uncharged crimes of wiretapping and actually tell the grand jury this is punishable by up to 5 years in prison for whatever reason. It doesn't matter. You choose because you think there's no jurisdiction or not. What Mello was obligated to do as the legal advisor to the grand jury with a duty of fair dealing, not to be an advocate, but a fair and honest broker, was to tell the grand jury, you must not consider any of that. You should not consider that evidence. You should not consider any possible penalty. So where did that come from her? We don't know. We also know that she sent evidence to Tully and I believe also Mello saying, I have taken clips from videos which show his intent in a folder named intent. We don't know where that
Let me
came
try
from.
to separate this out, because I'm trying to understand your argument very fairly, okay? It doesn't sound like there's any argument here this loss of exculpatory evidence.
Correct.
All right, so we can take that off the table, right?
Yes.
Is that a yes or a no?
Yes.
All right, so I don't need to worry about that. So what I'm now left with is the argument that the information, the only information that we seem to have right now with regard to Peters is the Scanlon non-indictment, right? Does that seem about right?
Well, and sending clips from videos in some folder named intent to Tully. That is what.
We don't know that any of that got in front of a grand jury.
We do not know if that's literally what he is. Correct.
So what we do know is that the Scanlon information got to the grand jury.
We believe so. I mean, I can't tell you if they took her version and found it
Well,
out.
we know there was testimony about that, or evidence about that.
There was testimony of that uncharged crime that
So
was
now,
just left there.
I'm really trying to hone down your argument, something I can get my hands around. All right?
The judge is like, I'm trying to hone down your argument to something I can disregard.
Now what we're left with is the question of whether or not the grand jury was, under Brown, tainted by the inclusion of that evidence. It's a high standard, really difficult, given Judge DeWood's findings already. Or whether or not Mello had an obligation to instruct the jury on the law about that now withdrawn or not pursued indictment. Does that summarize the argument?
It does, and Your Honor, I can't fathom a world in which a prosecutor.
I'm just trying to make sure I understand the argument. I don't need further argument on it. I'm just trying to figure out if that's the argument.
Of course, he should have instructed the grand jury to disregard prejudicial uncharged crimes, which could result in somebody going to prison. Yes.
But I still have to go back to the Brown issue of whether or not it affected the integrity of the grand jury.
You have to determine whether it affected the integrity and ultimately whether it mattered. And, in terms of, did it probably influence the grand jury, the Mayfield standard, something else the court should consider about whether any of this matters. In March of 2024, Mr. Mello took another shot at grand jury involving Mr. Carney and Karen Reed for essentially.
But not this grand jury.
No, but.
All right, then we don't need to go there.
Your Honor, if I can have 10 seconds of leeway, none of the misconduct occurred in that grand jury. And what happened? The same allegations, same type of evidence.
It's like, let him make the argument. He's like, so his argument that he's making right now is, look, Your Honor, when they tried to do this fairly, the grand jury told them to go fuck themselves. But when so they did it unfairly. So, yeah.
And that case was no bill.
That's a whole different ball, Max. That's.
The point is, could it have influence? We don't know.
I'm not gonna guess about the grand jury presentment that I've never read, I've never seen, and involves a far different set of facts than this, all right? Whatever, I don't know the details of what happened or didn't happen between Mr. Kearney and Mr. Reed. I don't know, frankly, to be here, okay? What I care about is this grand jury, okay? And much of that communication back and forth, allegedly with Reed, allegedly between, it's all before me. I'm not gonna draw an inference from that. I can't. You know that.
I'm not asking you, it's the same videos.
It's just a kind of.
No, Judge, I'm not talking about anything other than it was the same video evidence and Tully talking about the same things and
I'm gonna
admittedly.
guess there was a whole lot more to that grand jury than these videos.
Not much.
Whatever. It's not what I'm not reviewing.
Understood.
I'm not reviewing it. I don't have access to it, so I can't draw a conclusion as to whether or not the fact how it compares. So that's blatant. The last place I want to go down the road is figure out the Karen, any interaction with your client, Karen Reed. That's got no part in this trial. All right, not fair to anyone. Okay. All right. Anything else you want to tell me about this?
One other just response to something Mr. Cosgrove said when the court was asking him, why not just play or give the grand jury the opportunity if they so choose to have the videos, and the response was, well, they could have asked.
I didn't put a lot of stock in that, so I wouldn't spend any time on that.
Whatever they don't know, and the last point, Your Honor, is why rename the videos? Why say it comes from the intent? Why offer the opinions? It's to put their finger on the scale and to say, we believe he did it, you should believe he did it, and that's improper for a prosecutor to do as a legal advisor to a grand jury.
Fair enough. All right, I'll take it under advisement. Shoot.
So taking under advisement means he's going to come back and decide as to what's going on, right? So he's like, well, I don't know what I'm doing yet. I'm thinking about it. And usually that means that they want to write out a carefully written decision that, isn't just something off the cuff, right? Because it's easy to do something off the cuff, but when you know that there's the potential for something to get appealed, you're much more likely to be like, let's try to figure all this out and make sure that it's, appeal proof.
I just want to point out that from Commonwealth's perspective, the whole Scanlon argument is waived because they had the grand jury minutes at the time that they brought the last motion, including...
The Scanlon argument, it limited to the idea that they should have instructed.
Right.
Okay.
Right. The second point I want to make is the argument that they don't know what information came from Ms. Peters. I guess my response is, it doesn't matter. It doesn't matter that she has an animus against Mr. Kearney, that the
it matters to me.
Oil and water. Doesn't matter if the Commonwealth got those videos from Jack the Ripper or whether the Commonwealth got them from St. Teresa. The question is the video evidence authentic? And it is.
All right, tough on that. Next issue. Do we have the third party here?
Yes, Your Honor.
Yes.
All right. From the defense, I didn't get a response or opposition. Is there a response or opposition?
No opposition, Your Honor.
So you're fine with releasing these matters?
Judge, from our perspective, this is all out in the possession of the internet, if you will, and it seems like everybody has it and can look at it except Mr. Carney. That's another issue for another day.
Well, we returned it to
He's like, all of this evidence is already out there, and the only people who can't get it is my clients. So put it out there.
not. That was the order that the Commonwealth asked me to do.
Okay, hold on.
Yes, Your Honor, but it's, there's all sorts of,
Okay, this is it.
Okay, whoever's on the video, you need to shut down.
I don't know why courts have so much problem with this. Like, just mute everybody except for the people you know are supposed to talk. Like, because there's always some idiot who doesn't hit the mute button.
and further, Your Honor, Mr. Carney provided Attorney Diller with all these communications.
So this is not an issue. Because my intent, frankly, my first impression here is I want to protect Mr. Carney's rights not to have these materials, investigatory materials released. But if you're okay with it, I'm not going to.
Well, Judge, I appreciate that, and if you're inclined to do that, I certainly would ask you to do it.
Well, that's why I asked you if you opposed it, and you said no. So,
But if that's your inclination, Your Honor, any layer of protection we appreciate. But unfortunately, you know, if this is out on the internet, number one, he's given it to Mr. Diller as a pro se, non-party deponent.
so what do you need from Mr. Diller? What do you need from me if you already have it?
I don't know that I have it. I know that I just got a link from Mr. Carney a couple days ago because I went into our case.
All right, this remainder of it is less interesting. And so we're going to cut it here. And the reason why we're going to cut it here is because they just start going into procedural and less important stuff. And ultimately, we'll cut it here because we got other things to talk about. And if we get stuck on that for forever, we're not going to get through anything. So let's catch up on Super Chats here. And we can do a little doggo swoop. Doggo swoop. So Aqua says, okay, I'll toss some coins in for a chance to see Mount Garbage. Mount Garbage has gotten larger since then because we had to throw out a couch. So there's a couch in the backyard. Phoenix Fire, thank you for being a member. Much appreciated. Brentwood Cheek, Mount Garbage isn't a volcano, is it? I mean, it's too soggy to catch fire. The World Wonders, just make sure you don't accidentally dox yourself with pics of damaged stuff that might have an address on it or something. I made that mistake once. No. That's not the doxing concern at the moment. Which doggo is which in the swoop? I can tell you that in a moment. Not for Mount Garbaggio. Still have trauma having seen the insides of people's houses on the outside after Hurricane Harvey. Fair. So somebody was asking which dog is which in the swoop. So the little one that, and I say little because, she's big, but, littler, that is initially lying down and gets up, that is Zora. The bigger one who is sitting there with his tongue out and just kind of chilling, that is Potter. So that's the two doggos. Susan says, for proof of hard work, i.e. Mount Garbage, thank you. Lindsay Metcalf, are we calling the Garbage Mountain Proctor or MSP? Nice. Sarah Gabone, Mount Garbage, how'd you find a picture of my ex? Aqua says, I'd say you've heard a belt of rum or two. Fair. I got to drive after this because I've got to go back to the family's house. So, Alpha, thank you for being a member. I'm not sure if you changed that on purpose. Nella Brown, hope your leather working tools are okay. The leather working tools are in the garage. The garage is above ground, so all of that is fine. So, Alpha says clients keep sending me AI generated contracts to review and don't like me telling them they're crap. FML. So my retainer agreement right now has a section on AI, which basically says because most stuff that criminal defense lawyers do is flat rate, right? It's like it's like stepped rate usually. It's like if you do this, if we do it, if we do a guilty plea, it's this much. If we go to a trial, it's this much per day, like those kinds of things. But I tell clients, like, this amount does not include at all any review of AI generated shit, because your AI generated shit is extra and it will be billed on an hourly basis, because you get clients who are like, here's what the AI said. And it's like, yeah, it's bad. Stepanova, couch replacement fund. Pups need a place to nap. Yes, they do. Our current game plan, our current hope is basically to hold on with this place being half fixed. And we're going to do like half fixing until we can build a new place here. So, we're probably not going to re-insulate the walls. We're probably not going to re-drywall the walls. We'll just kind of leave it. And, see, and then try to get ready to be in a place where we can then, so we're talking to an architect now, and the architect is like designing a place, and what do you call it? Then once we get the, once we get that, we got to get into a place where we can get the bank to loan us money to knock the place down and build a new place. So that is the hope. That is the dream. Can you put the trailer in the backyard while you build? Our game plan is to build a garage with like a mother-in-law suite. And so the hope is to build the garage first. Like, what do you call it? And then, so like, we'll be in the house, knock down the garage first, build the garage, new garage with the mother-in-law suite, and then we move into the mother-in-law suite, and then the house gets knocked down and we live in the house, right? That is the hope. That is kind of our thinking and our plans and our, our thoughts. But yeah, that's kind of the notion there. Cricket, thank you so much. Aquas is always ready for Zora TV. She is such a cutie. Need more doggo pics. I will provide more doggo pics. Pupper clips are always wanted. She's a cutie. I hope that hanging out with us tonight is therapeutic for you, Runkle. Yes, although I have a lot of stress because there's so many things I need to do. So, yeah. Alberta shouldn't have smoke after that month of rain. It does. Who ends up in the mother-in-law suite when done? So the hope is to occasionally Airbnb it in the back, but also to like have it available for like, if family visits, if, if other people visit and so forth, then we've got a place to put them, right? If we, if my brother and, his kids visit, they can go into that suite. They've got a place to go that, and yeah, if Rob comes out, they can stay there, like all of those things, right? Rob says, I know a guy local who does demolition, could probably do your place when you're ready for it. Awesome. So that would be, that'd be good. Inching toward that Zora goal. Thank you. Purple Pixie Dust says, glad you're back. So sorry for all the drama. There's always drama, but you roll through it. Nyambi Jackson says, Basement Recovery Fund, I hate that you're being set back in your nonprofit goals, hoping every little bit helps. Yep. Catherine Lynn Fraser, the mega motion is so persuasive, but it's Massachusetts. Yeah. Be liberal, hand over the Zoravid. Love it. My 10-year-old pup tells me it's her bedtime, so I'll join replay crew eventually. Best of luck with the restoration, Runkle. Thank you so much, Aqua. Phoenix Paw, I assume all U.S. prosecutors always lie. There are good ones out there. The Jet JJ, thank you so much. Laura J. Riker, messed up Massachusetts never gets old. It's a weird place. Honk Banana No, I purchased this super chat to encourage and remind Runkle to establish a new goal and to remind autocorrect not to attempt to alter Honk Banana No. The Jet JJ, story and beer? Yes, it's a story about beer. Tough Cookie, good to see you. Good to see you too. Honk Banana No, how have we not fulfilled the beer story goal? Shame. I'll have to see where we're at. For the record, wetting the chair is not recommended. The chair is not in the basement. The chair survived, unfortunately. Law-abiding rebel, Potter's Toy Fund. Thank you so much. Philip Edmondson, favorite Canadian firearm lawyer. Keep it up. Thank you so much. Chloe Diagnosed Snarky, could we get a Chewy Amazon list for replacing doggy toys? Please. I will have to work on that at some point. So, yeah. Sometimes bad things happen, but you get somewhere better because of it. It's going to be an expensive trip in between now and then. Why not just do a giant remodel of your current house? My current house was built in like the 1950s. And it's getting old. It's not really viable to do. So, yeah. I've got to, I got to go and, yeah. It's getting to the age where it's starting to, where it's starting to, like, it's going to be expensive to just keep, like, patching it together. So, yeah, it just doesn't make sense to do. There's, yeah, it's going to be a whole project there, and yeah. All right. Let's see what else or what next here. Yeah, and this is basically it. The flood ended its lifespan about a decade early. That's about it. That's about it. And the other thing about the new house design as well is some of the stuff we want to do is not super expensive to do in a new house, but is really expensive to do in an old house. So one of the things Mrs. Runkle and I are looking at is we are looking at trying to build to age in place. And, just as like, this will be our forever house. This is a place we can stay forever. And yeah, so part of that is accessible design. And part of that is we're going to put in, hopefully, an elevator. Now, we might not be able to afford the elevator now, but putting in an elevator shaft is not that expensive when you're building. It's really, really insanely expensive to retrofit an existing house with an elevator. So, what we will probably have is like an elevator shaft that will be a series of closets on different floors. And then later we can put an actual elevator in there so that, we can go up and down. Why not get a standard stair lift? Because they suck. Everybody who has a stair lift hates them. Book Dragon says, do you have the ability to do everything on one story? Not really. We're going to need the elevator for the, for the age in place. So, yeah. Yeah, and the stair lift won't work for the doggos. So, all right. Let's talk about Frogan. So, if you don't remember what was going on with Frogan, Frogan was being sued by TED Entertainment, which is Ethan Klein. So Ethan Klein was suing Frogan over the content nuke, which is the Hassan Piker content, or like the Hassan Piker nuke. And so basically, what had happened most recently is that Frogan had failed to defend the case. And when you fail to defend the case, you get noted in default. Now, that had happened. She was noted in default, but it wasn't final. It wasn't like the end of everything. And then something interesting happened. Because one of the other people who's fighting Ethan Klein, one of the other people who's getting sued by Ethan Klein, Denims fought Ethan Klein and fought him on and basically said, look, this is fair use. Fuck you. And Denim's lawyer managed to get the case thrown out. Denims won. So Frogan lost by not defending, and Denims won. And then there's a little bit of an interesting development. Content nuke, that was the trap, yes. Ethan Klein, yes, it's Ethan Klein that's suing them, not Hassan Piker. They like Hassan Piker, sort of. So an interesting thing happened, and that is this. I gotta... So, notice of appearance or withdrawal of counsel. Frost LLP. So we've got Benjamin Grush is coming on, but also coming on is Benjamin G. Cassis. Now, if you have been following this case religiously, which I know most of you haven't, then you might notice something. And I don't expect you're going to notice it, so I'm going to tell you what it is. The new lawyers that Frogan has brought on this case are Denim's lawyers. So Frogan is like, I'm bringing in Denim's lawyers because Denim's lawyers won, and now, yeah. Yes, those are business addresses and phone numbers. If you call those, you just get their business and don't hassle them. I like an air fryer. Air fryers I do like. So I restarted the beer goal, by the way, so that you can, or for the beer story goal. So then what happens? Well, this. And yes, I do think Denims was in the best position to win from the allegations, but joint stipulation to continue the hearing on plaintiff's application for default judgment as the parties continue to discuss a potential stipulation to set aside the default. So, whereas on June 19th, plaintiff TED Entertainment commenced his action, and on August 5th, the parties entered into a joint stipulation to extend Frogan's responsive pleading deadline to October 3rd. May 19th, TED Entertainment requested default against Frogan. May 20th, the clerk entered default against Frogan. June 30th, TED filed an application for default judgment pursuant to the rules of Federal Rule of Civil Procedure. And then on July 9th, Frogan retained Frost LLP as substituted counsel July 10th, the new council contacted TED Entertainment lawyers regarding whether Ethan Klein basically would stipulate to setting aside the default. July 13th, they met and conferred regarding a potential stipulation to set aside the default. Frogan's potential motion to set aside the default and the pending application. So they have agreed to continue the hearing on the application by 6 weeks so that they can discuss whether the issue can be resolved by stipulation in order to obviate the need for motion practice in connection with the application and a potential motion to set aside the default or the default. Whereas good cause exists for extending the application, it's not intended to delay or for any other, they say reasonably, it should be unreasonably delay. Or so basically what's happened here is that Frogan is like, I need to fight and I need to get Denham's lawyers. And so she brought in Denham's lawyers, and right now Ethan Klein has not agreed to set aside the default, has not agreed to anything, but they've agreed, well, the one thing that they have agreed to is we can argue about this later. Right? We can discuss this later to give us some more time to figure out what's going on. And it might be that they have to fight over whether or not there's going to be a default or not. That might be how this goes, or it might be that they work it out. Sometimes the way this ends up working is that sometimes when you've got somebody noted in default, and they want to set it aside. Sometimes, like for instance, you might agree to set it aside on the payment of cash. Sometimes you can be like, look, noting it in default cost us like 10 grand. So pay us the 10 grand and then we'll fight this, right? Sometimes there might be other things that are going. So, yeah. So, yeah, I thought this was interesting. Frogan looked like she was just rolling over and letting the case expire, but instead instead she's going to fight it, and she's brought on Denham's lawyers, and it's going to be interesting. All right, now let us look here. We have no additional super chats that have come in, which I think means people might be tiring out, and that is fine. People can tire out. Do people want to go over Kouri Richins, or are people done? I don't know how people are feeling on that. We've got the beer story goal, but I don't know. Are people wanting to go to bed? What is it? Oh, Nightbot is going nuts. All right, people are saying more, please. All right, and people want to see Kouri Richins. Cool. We shall do so. All right. So, and yes, bribing is always helpful. All right. Although I get that people are, yeah. So this was brought, what's the date on this? This was a while ago, and the reason why we didn't cover it before then. So this was brought June 30th, but I've been away. I've been, stuff. So, Kouri Richins wants a new trial. So Kouri Richins is like, I know I had first trial, but what about second trial? And I think it's gonna be interesting, because they make all sorts of allegations, including they allege bias on the part of the judge. And because they allege bias on the part of the judge, what we actually see is the judge's response here. This is a little bit of spoilers, but Judge Mrazek goes, "You're alleging bias? I'm out. I'm going to let another judge handle this one because, there's a conflict of interest." And I think that that is actually a very reasonable thing for the judge to do. I don't think Judge Mrazek was biased. I don't. I think that there are times when the judge was like, look, counsel, you're kind of sucking at this. And maybe you should suck a little less at what you're doing. But that's not really biased because he was trying to give them every break that he could. And yeah. So the court is like, I'm out. I'm not ruling on this. You need a new judge. So, and yes, Ethan Klein is the H3 podcaster. Absolutely. Yep. So, let's have a look at this motion for new trial. So here we go. Pursuant to the rule, Kouri Richins hereby moves this court to grant a new trial due to irregularities in the trial proceedings and cumulative error, and presents to the court the attached video clips and documents in support of her request. So, statement of facts. Ms. Richins was originally charged with 1 count of criminal homicide, aggravated murder in violation of the Utah Code, and 3 counts of possession of a controlled substance in violation of further law. Prior to the prelim on August 27th and 28th, the information was amended 2 times. So at trial, she was found guilty of 1 count of criminal homicide, aggravated murder, 1 count of attempted criminal homicide, aggravated murder, 2 counts of insurance fraud, and 1 count of forgery. Pursuant to Rule 24, the court may grant a new trial in the interest of justice if there's any error or impropriety which had a substantial adverse effect upon the rights of a party. A new trial is not necessary, however, when an error is sufficiently inconsequential that Utah courts conclude there's no reasonable likelihood that the error affected the outcome of the proceedings. In other words, a new trial is not merited where an error is harmless. The courts tend to find that errors are harmless even when they are what we think is pretty serious errors. So, be aware of that. Harmless error is a big sphere. So, a motion for a new trial is generally permitted for correcting errors made in the trial court or for reviewing a conviction obtained by unfair or unlawful methods. Ms. Richins' conviction should be vacated and a new trial granted for the following reasons. 1. The court's clear demonstration of bias in favor of the state displayed before the jury deprived Ms. Richins of a fair trial. 2. The state's repeated reliance on other crimes, wrongs, or bad acts, and the admission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several general categories, went far beyond the court's pretrial rulings, violated various rules, and resulted in substantial undue prejudice. So basically, they are saying that the judge was way too snarky to Kouri Richins' counsel, and they also allege that that basically all of the financial shit shouldn't have come in. Now, if you're wondering, wait a minute, does this have any parallel to a certain other trial where financial crimes being admitted was the basis of an appeal? If you're thinking, has Murdaugh entered the chat? Murdaugh has entered the chat. Because they are going to say, well, you gave Murdaugh a new trial, so we get a new trial too. So, argument. The court's repeated assistance to the prosecution and disparate treatment of defense counsel before the jury denied Ms. Richins her right to a fair trial. Throughout trial, the court repeatedly interrupted defense counsel, corrected counsel in ways that suggested to the jury that counsel was mishandling witnesses, because you were mishandling witnesses. You kind of sucked. Assisted the prosecution with its objections, and curtailed the defense's objections. On at least one occasion, the court did so in a manner that made clear to the jury that it was offended by defense counsel. This misconduct created an appearance of bias against Ms. Richins and in favor of the prosecution, depriving Ms. Richins of a fair trial. Now, the judge was a little snarky at them. But the thing is that they were really sucking in the trial. And so you kind of get to a point where it's like, how much is the judge being patient with you sucking an indication of bias? I'm like, this is not wowing me so far, but we'll see where it goes, right? So, carrying on. Pursuant to the 14th Amendment, a defendant has the right to an impartial judge, and the presence of a judge who is not impartial constitutes a structural defect in the trial mechanism that violates the United States Constitution and requires reversal. So, structural defect is important because when you've got a structural defect, it's not really fixable. It's just like, nope, that is, that is a something that you can't really undo. So, okay. So the we call it. They have a quote here: "A cardinal principle of our legal system is that courts of justice act upon the belief that if guilty, a party will be so found after a fair trial. Both the ends and the means of a trial must be fair, and no matter how abhorrent the offense charged or how evident the guilt, an accused has an absolute constitutional right to a fair trial before an impartial judge and an unprejudiced jury." So, further, courts have long recognized that a trial judge's comments and actions carry a great deal of influence with the jury. I'd agree with this. Absolutely, the judge has a strong impact on the jury, right? Because if the jury, they don't just take the judge's comments the way they might take comments from counsel. They don't take the judge's comments the way they might take, some dude who just wanders into court and says, "They suck." The jury's going to be like, who cares? But if the judge is like, "They suck," that's a different scenario. So, you got to look at that and you got to consider it. In this matter, the court engaged in repeated conduct that denigrated defense counsel both in and out of the presence of the jury. The court was often impatient, critical, and hostile towards the defense, and only the defense. The court frequently interrupted defense counsel, telling them to pause or focus. Never was the state told to focus. And that's because the state had focus, right? The state wasn't told to focus because they didn't need to be told to focus, because it's like you don't yell "stop, drop, and roll" at the person who's not on fire. You yell that at the person who is on fire. So it's like, why did they only yell "stop, drop, and roll" at me? Why didn't they yell it at the other side? It's like, because the other side not on fire. No fire. Therefore, no stop, drop, roll. All right. So they have footnotes. At the bench, the court angrily criticized Ms. Nestor's objection, telling her to slow her roll and reminding her to read the ruling that I issued yesterday to try and avoid plain error to help your client. Further, the court tells Ms. Nestor that she needs to wrap it up because I have a parent-teacher conference to go to, and my son barely recognizes me. So they also have a video clip that shows the court interrupts Ms. Lewis in a demeaning manner, saying, "Please pause." Seconds later, the court follows an interruption of the prosecution with an apology. When Ms. Lewis expresses frustration at the court for changing a ruling made at the bench, she is told twice to stay focused, and "Don't do that. Please stay focused." Yeah. So here's the thing. You have to when you're writing an appeal, you have to kind of spin the facts a little bit. But I think they're spinning a little too hard. Because, like, the judge quite frequently told both sides to be like, chill. I do remember him telling Bloodworth at times, like, you got to chill out. So they note, during day 4 of the trial, the court interrupted defense counsel on 24 separate occasions, while only interrupting the state 13 times. Okay, but why did you pick out one specific day? Like, is that day usual or is that day exceptional? Because if different days the prosecution was interrupted more, and one of the things about the interruption thing is that you're going to get interrupted more if you talk more. So one of the things you will find in like assessments of workplace dynamics is they'll say certain people are interrupted more than other people. And the thing is that the thing that gets you interrupted the most in conversations, the factor that is most predictive of when you're going to get interrupted, is how much you talk. More talk, more interruptions. And if you talk all over everybody, then you're going to get interrupted, and the other side probably isn't. And somebody's saying, people were saying, get well soon. I came back. My basement was flooded. I got the flu. I got better. But I'm still dealing with the basement shit. So, yeah. So this normally may not show bias, but the interruptions of defense were curt, cutting off statements and arguments, while interruption of the prosecution were followed by apologies, were often to help with logistical issues or to aid them with objections. I don't think this is going to go anywhere, but okay. This pattern followed throughout the trial. On day 1 alone, the court interrupted the defense 36 times, as opposed to interrupting the prosecution 20 times. Interruptions of the prosecution were generally clarifying, accommodating, or logistical. For example, on trial day 1, the court interrupts the state to help clarify their argument and to redirect the state's argument into the court's framing. In 11 to 24, the court interrupts the state, but only to confirm a fact helpful to resolve an issue. At page 312, the court interrupts the state to inform them that their information is helpful. To the contrary, when interrupting the defense, the court uses language such as, that doesn't track. Move on. You're jumping the gun. I think it's premature. This is only day 1 of the trial. A full review of the trial transcript demonstrates that this disparate treatment of the defense was persistent, prejudicial, and well outside the bounds of neutral courtroom management and administration. Again, this really, to me, feels more like the stop, drop, and roll, right? They told us to stop, drop, and roll so much more than the other side, and it's like, you were the ones catching on fire. There's a question of, like, was the court biased towards you, or did you just suck? And I feel like that's the problem that they have here, is that they just kind of suck. And yeah. Okay. Like that. I don't know if this will go anywhere. I mean, I could see a court, going, well, we're just going to look at the numbers, but I don't think it's likely. I don't think this is going to work out for them, but they can try. Now, I should say, I don't think it's frivolous. I would certainly make the same argument if I was in their shoes. Right? Because you got to do something. Kouri Richins is going to go to jail forever. And like, you know, forever and a day. So, I mean, what else are you going to do? You got to argue something. You're not just going to be like, well, best of luck in jail forever. You got to argue something, right? And given that you've got to argue something, I mean, this is something. I don't hate that they're arguing it. I don't think it's going to succeed, if that makes sense. So, it doesn't make me mad that they are fighting this. If that, you got to do something. This is what part of being a defense lawyer is sometimes. I am not persuaded thus far. And I mean, hey, maybe it gets better. So, in addition to speaking in a disparaging and condescending manner to the defense, the court would also reframe arguments in a way to help the prosecution. One strong example of this took place on day 10 of the trial when the defense was attempting to elicit testimony of the victim's prior use of pain pills. Not only did the court interrupt the defense, but also continuously rephrase the argument, insisting that the defense use the term illicit street drugs, defining such drugs in a way that does not include prescription pain pills. During this argument, the court did more than frame the issue in terms favorable to the state. It affirmatively accused Ms. Nestor of knowingly misusing the court's chosen definition, a definition unsupported by any expert testimony or evidentiary basis, and instead supplied by the court itself. Other examples of the court speaking down to defense counsel are noted at attachment A, where the court accuses Ms. Lewis of intentionally ignoring what the court is saying and informing defense as an answer to the objection that they can call their own witnesses in their case, thereby burden shifting. It's not burden shifting to say that you can call evidence. There is no burden on the defense, but if you don't call evidence, then you may not have the evidence, right? Like, you're not required to call your client, but your client's version of events may not get in front of the jury unless you do. That's so. At day 11, 49 minutes, the court didn't simply rule on Ms. Nestor's objection to relevance, but commented on the objection in an extremely disparaging and condescending manner, saying, "You don't see the relevance?" At day 11, number 50 or 57 minutes, the court was extremely condescending towards Ms. Nestor's request for a continuing objection. And at day 14, page 14, the court shot down an objection by Ms. Lewis during closing, interrupting her in the process and strongly saying, "Please be seated." This was particularly prejudicial to the defendant as it was in front of the jury, indicating that the court was angry with the defense and making it clear that objections during closing would not be tolerated. I mean, you don't normally object during a close, and the judge was probably anticipating it and being like, no. The state then went on to make several objectionable statements during closing, leaving the defense with no remedy in front of the jury. They note Ms. Nestor did make a record outside the presence of the jury after closing arguments were complete as to the improper comments made in the state's closing, although, of course, by then, the jury had already heard the improper arguments. That's usually how objections to closings are done, is you object and that the court may issue like a corrective instruction. In rare circumstances, the court may direct a mistrial. 5 goals needed in 4 minutes. Come on, folks. You can do it. In State versus Beck, the court addressed this issue, holding that judges must be particularly cautious with their treatment of counsel in front of a jury, and judges' conduct before a jury is critically important because it directly implicates a defendant's constructional right to a fair trial. Like, the defense counsel can't say, "Defense, are a bunch of jackasses to the jury, right? Okay, fair enough. So when a judge abandons impartiality, the resulting bias can infect the entire proceeding, violate due process, and require reversal of a conviction, regardless of the strength of the evidence. Courts have long recognized that a trial judge's comments and actions carry a great deal of influence with a jury. Can you imagine how she would have handled, like, Judge Bev? Yeah. Oh, and hey, Kurt, good to see you. A trial judge's position before a jury is overpowering. His position makes his slightest action of great weight with the jury. Oh, jeez. Leg spasm. Thus, in order to assure a fair outcome and maintain public confidence in the legal system, it is paramount that the trial judge maintain the appearance of impartiality, especially in jury trials. So, all right. A full review of the trial transcript clearly shows that the court was demeaning and condescending to defense counsel and in contrast was friendly to the prosecution, often helping them with both their objections and the framing of arguments. Much of this conduct took place in front of the jury, and as Beck stated, a trial judge's position before a jury is overpowering. Trial judges sit high above everyone else in the courtroom. They preside and they decide. They welcome and protect the jurors, accommodate their schedules, and make sure they have everything they need. The influence of the trial judge on the jury is necessarily and properly of great weight, and his lightest word or intimation is received with deference and may prove controlling. The trial judge often banters and jokes with the jury, and in this case was no different. The jury looked up to the trial judge, laughed at his jokes, and engaged favorably with him throughout the trial. A full review of the record makes it clear that the court let it be known to the jury that it favored counsel for the state and their positions. When the prosecution raised concerns, the court often accepted, clarified, or helped frame them. When the defense raised concerns, the court more often responded with interruption, correction, skepticism, or curt commands to move on. Does our friend want company on stream? I can make flooding jokes if it'll help. No, I've got to sort of get through this. We should do a stream together at some point soon, but today is not a great day for it because after this, I got to do like 3 or 4 more hours of work. So it's gonna be a night. In addition to the court's treatment of counsel, a full review of the trial transcript shows multiple instances where the court suggested the defense objections could be resolved by the defense calling their own witnesses, thereby shifting the burden by instructing them to put on the defense. Yeah, he's telling you if you want the evidence in, you have to call the evidence. Yeah. That's not burden shifting. It just isn't. Okay. In addition to the court's treatment of counsel, the rule with respect to the scope of cross-examination continues to be that it is limited to the subject matter of the examination in chief, or in more modern parlance, to the limited scope of the direct examination. While enforcement of this rule is generally within the trial court's discretion, in a close case, the rule must not be so strictly applied as to deprive the defense of an opportunity to present to the jury a vital element of the defense, here government inducement, as an element of the entrapment defense on which the accused has the burden of proof. You could call these people, right? You could. In a particularly heated debate with defense counsel regarding argument over the state's request to put in additional statements by Carmen Lauber after she'd already taken the stand, the court told defense that they should recall Ms. Lauber in their case if they wanted to question her on those statements that the state did not put in during her testimony. At times, the court went so far as to tell the defense to put the defendant on the stand rather than allowing certain lines of questioning. What the court said was, you can put the defendant on the stand if you want, but yeah. In addition to disparaging defense counsel, the court repeatedly aided the prosecution by supplying objections the state had not made and on at least one occasion, sua sponte objected on the state's behalf and then sustained its own objection. Although a trial judge may control the courtroom and rule on objections, the court may not abandon the role of neutral arbiter and assume the role of advocate for one side. I don't think that happened. The Supreme Court has long cautioned that the judge's influence over a jury is uniquely powerful, and that even slight judicial intimations may affect the jury's view of the parties and the evidence. Utah courts recognize the same principle. A judge must maintain both the actual neutrality and the appearance of neutrality, particularly in a jury trial, because judicial comments or conduct suggesting favoritism can undermine public confidence and deprive the accused of a fair trial. When the court supplied objections for the prosecution and then sustained these objections, the court did more than manage the proceedings. So I'm sure that the moment that they're referring to here was that they had, there were moments when the prosecution stood up to object and the judge was like, is the objection this? And the prosecution is like, yep. And he's like, sustained. And this happens in basically every trial. Like, there are so many trials where the judge is like, okay, the objection is this, right? And the prosecution's like, yep. And he's like, cool. And the reason why is because the judge can see the objection too. In fact, there's a lot of trials where, you know, you see that one side or the other stands up to object and the judge is like, sustained, even before hearing the objection, because they're just like, right, I know what the objection is. I can remember a moment in one of my trials where the prosecution said something that was really fucking dumb, like really obviously objectionable. And the way objections typically work in my area, in, you know, here in Alberta, is that, you know, you stand up and then the other side stops talking and sits down and you, you know, you do the, you know, and then you state what your objection is. Well, the judge was like, you know, I stood up and the judge is like, sustained, you know, because it was obvious what my objection was. It was really, really obvious. The prosecutor was trying to tender my client's record, which is not permitted. So when the court supplied objections for the prosecution, then sustained the objections, the court did more than manage the proceedings. It communicated to the jury that the state's position had the court's approval and that the defense's questioning warranted judicial intervention. Even the prosecution itself did not object. That appearance of alignment with the prosecution is precisely the type of conduct that can infect the fairness of the trial and requires a new trial. We will do the beer story very quickly after. We're going to wait for a break and then we'll do the beer story. Overall, based on the court's conduct, it often appeared that the defendant was not facing a single adversary, but rather had to bear the consequence of a judge who at times acted as a second adversary and who appeared to disbelieve either defense counsel or a defense witness. I mean, I would disbelieve defense counsel here because y'all are not really being super truthful here. Like super accurate recounters of the facts here. As a result of the court's repeated prejudicial conduct toward the defense in this case, the defendant did not receive a fair trial by a neutral arbiter of justice. Because Ms. Richins is asserting herein a claim of bias on the part of the judge, the court should reassign the consideration of this motion to another judge. We're going to skip that because the judge is just like, yep, that is what I'm going to do. So they're like, we need a new judge. And the judge is like, sure, fine, no problems. So, beer story. So we had the flood, and in the basement, I had a box of beers, specifically Modelo's. Modelo, Especial, just sitting there. And the beers got flooded. And the cardboard box the beer was in disassembled, but the beer were in bottles. And so I was like, okay, fine, whatever. But I was just leaving them alone initially, but I spent a day cutting up carpet, chunking it up, ripping it out, chucking it in the backyard. And it was like 10 at night. So I'm like, well, the bottles are they're sealed. So I took one of the bottles and I took it upstairs. I rinsed it off. I soaked it. I sprayed it with hand sanitizer to clean it. I washed the hand sanitizer off. All of that. So I've got this, nice, yeah. And then I was like, okay, my reward for doing all of this shit is going to be this beer. It's going to be great. And so I drove back to where I was staying. I chill this beer because the beer kind of got warm on the way back. I put the beer in the freezer. I let it cool down. I had this nice cold beer. I pour it into a glass. I've got this great cold glass of beer. And I go and I sip it. And I don't know what happened to this beer. I do not know what the deal was. But this beer tasted like shit. It tasted so bad. And I think maybe it was like warm flood water or something. But it just... I was like... And it wasn't that it was contaminated with, flood water or anything like that. It was just that it was not good. And so I was just like, fuck. And I had been just so looking forward to this beer, and it got skunked. It was wrecked. It wasn't that old. It should have been fine. But I ended up pouring out this beer, and I tried other beers from the, they were all wrecked. I tried another beer out of that, and it was also skunked, and it's like, yeah. After all of that, I built up this beer was going to be the thing waiting at the end of this big, long day of all of this. Didn't happen. I taste it, and I was just like, out. Off it goes. So, yeah. All right. Let's finish this up here because they do make another argument. And the other argument is the state's repeated reliance on other crimes, wrongs, or bad acts, and the admission of evidence proving Ms. Richins committed a wide-ranging financial crimes over numerous years in several general categories went far beyond the court's pretrial rulings, violated the rules, and resulted in substantial undue prejudice, denying Ms. Richins a fair trial. So prior to trial, defense filed motions in limine seeking to exclude from trial evidence of over 30 other crimes. Wow. Wrongs or bad acts connected to Ms. Richins' business and / her financial dealings over a period of several years. The problem is that in this particular case, I suspect the reason why they had trouble excluding all of this was because it's relevant to the prosecution's theory of motive, right? So, yeah. On January 7th, the court held a hearing to determine to what extent all of Ms. Richins' alleged financial misdeeds spanning years before Eric Richins' death could be admitted at trial. The court gave the state some general guardrails, attempting to avoid issues at trial. So, in trial, the state went far beyond the court's pretrial rulings and introduced the testimony of Chelsea Barney and Brooke Carrington, going into great detail about numerous financial misdeeds. Ms. Carrington spent an entire day on the stand testifying about bounced checks, false bank statements, misleading communications with lenders, mismanagement of business affairs, sloppy accounting, improper tax accounting, and on and on and on. Ms. Barney testified about how she lost her life savings and her home when Ms. Richins mishandled a real estate transaction for her and allegedly lied about it. The defense objected to all of the state's attempts to inject allegations of financial and business fraud and/or dishonesty into the trial despite the court's pretrial rulings, and each and every objection was overruled by the court. I think if they have an argument, the strongest argument they have is with respect to Chelsea Barney. And Chelsea Barney is like, is basically that one I thought might have gone a bit too far because it does make her out to be an absolute sack of shit, right? So if they have an argument, that's the argument. So the very beginning of the state's closing argument specifically referred to Ms. Richins taking out a HELOC without her husband knowing about it years before he died. I mean, that is their theory of motive, right? So see attachment E. 7 pages of the state's closing argument focused on this testimony of Carrington and Barney. Ms. Richins' case is similar to the case of State of South Carolina versus Richard Alexander Murdaugh from the South Carolina Supreme Court. Wherein the Supreme Court for the state of South Carolina held that it was overly prejudicial to allow the state, under the guise of proving motive, to introduce vast amounts of evidence showing financial misdeeds of the defendant spanning years of time prior to the murders of his family. Like the Murdaugh case, Ms. Richins was denied a fair trial due to the undue prejudice of financial wrongdoings permeating her trial. The only appropriate remedy is a new trial. Except the difference between, at least as I see it, the difference between Murdaugh and this case is that in Murdaugh, the connection to the financial misdeeds was kind of fuzzy-wuzzy. And, fuzzy-wuzzy was a bear. Whereas in the Kouri Richins case, the Kouri Richins financial aspect was very much directly to it, because Kouri Richins had insurance policies and shit like that. And the thing is the Becky stuff was so Becky was the primary basis for overturning Murdaugh's case. But the appeals court did say in Murdaugh, they did say, look, the financials went too far. We would have also flipped that as well. So they said even if Becky wasn't a thing, we would have flipped on this. But Murdaugh went on for weeks on his financials and he wasn't charged with it. They spent a couple of days on her financials, and her financials were far more directly connected to it, right? Far more connected. Alternatively, this court should grant Ms. Richins new trial under the cumulative error doctrine. So under the cumulative error doctrine, a conviction should be reversed when 2 or more errors occurred, and each error standing alone has a conceivable potential for harm, and the cumulative effect of those errors undermines the court's confidence that a fair trial was had. So, if we look at cumulative, what cumulative error means, how do I put this? What's a good way of explaining cumulative error? So let's imagine that you're like, trying to think of the best way to put it. You start a new job, and your coworker meets you and is like, "Hey, Joe," and you're like, "Oh, sorry, I'm not Joe. My name's Ian." And they're like, "Oh, shit, sorry. No big deal, right? No big." But let's imagine that every day they come in and they're like, "Hey, Joe," and you're like, "I keep telling you, it's not Joe." Eventually, that becomes a bigger deal, right? And similarly, if you have things like, if you imagine a coworker going up to his female coworker and being like, "Nice shoes," and he does that once, it's like, okay, he's commented on her shoes once. If every day and every hour, this guy comes by to comment on a different aspect of his coworker's clothing, then it's gonna get to become harassment at some point, right? At some point, there's going to be a hostile workplace thing, right? So that's kind of the cumulative error aspect of things, right? So they note a court's confidence is more likely to be shaken when the errors work together in a pernicious manner so as to cause more prejudice than the mere sum of their individual errors. Cumulative errors refers to the number of errors which prejudice a defendant's right to a fair trial. The cumulative error doctrine applies when a single error may not constitute grounds for reversal, but many errors taken collectively do. Cumulative error requires reversal if the cumulative effect of the several errors undermines this court's confidence that a fair trial was had. Importantly, the doctrine applies to errors that's substantial enough to accumulate. I think there's a missing word in there, but okay. It does not apply to errors found to be so minor as to result in no harm. When considering reversal under the cumulative error doctrine, not only must a court make a determination that an error exists, it must also make a separate determination that the error could not conceivably cause some harm before it adds the error's effect to the cumulative error scale. You'll note that that's just one, that's just like one big paragraph. I don't think they're really riding this one too hard. So, conclusion. The court should recuse from consideration of this motion. They did. And an evidentiary hearing should be scheduled before the judge assigned to the motion to present evidence and argument in support of Richins' request for a motion for new trial. Okay, so that is their motion. There is there is like 65 pages of transcript that they attach to it, which we're not going to go over because that is a whole lot. But I don't think this is going to succeed, but I don't think it's frivolous. I don't think it's like, this isn't to the point where I'd be like, hey, this is idiotic and it should never have been filed, right? This isn't at the point where I would be like, we need to sanction these people for filing it. I just don't think it's going to succeed. And so, I mean, those are different things, right? Where it's like, is it going to succeed versus is this complete dog shit? I haven't yet seen the response to it, and I expect that we'll see a response to it coming fairly soon. And, we'll see what comes out and, sort of how this goes. But it's not wowing me. We'll just put it that way. And, yeah. Oh, we haven't talked about the Tates. We ain't talked about the Tates yet. Let's talk about the Tates. So, if you don't know who the Tates are, Andrew and Tristan Tate are manosphere influencers, and so what I mean by manosphere influencers, people are saying I gotta swoop. We will swoop. So they are manosphere influencers who also are currently facing criminal charges in like at least 2 countries, Romania and the UK. And they have been on Twitter for the last little bit, daring Florida to arrest them. So anyway, they got arrested in Florida. And now, what they're accused of is a variety of sexual offenses, including, sexual assault, and also bad pictures, we'll call it. And the thing is that I get people like, there's probably going to be some sort of tater tots in the chat going, hey, the Tates are lovely people. They did nothing wrong. And because I've had those before where people are like, oh my, and the ones who are really deep into it are like, this is just the Matrix fighting back, because the Tates talk about the Matrix being like some conspiracy against them. And yeah, no, that is not actually their chat's name. It is just what I call them because it's funny. I'm not the one who came up with it, by the way. Lots of other people call them the tater tots and so forth. So their lawyer has put out a statement basically saying that this is an attempt to suppress their freedom of speech. And I'm just going to say there is no freedom of speech to sexually assault people. There is no freedom of speech to share bad pictures. So what is going on right now is that the U.S. has an extradition treaty with the UK. And so they were arrested on behalf of the United Kingdom. And the U.S. now has to determine whether it's going to send them back. And there's all sorts of considerations that go into this. The considerations include whether or not this is a publicly motivated trial. This includes whether, like, the strength of the evidence that's against them. This includes whether the offense would be considered a crime in the U.S., and the answer to that is yes. So all of these are, various considerations on this, but ultimately it will come down to the political, or, comes down to that decision. And so the lawyer is out there noting, he says, we've never seen a scintilla of evidence that indicates these guys are guilty of anything. They're being punished and attacked for what they say, not for what they've done. You can love them, you can hate them, but nobody should go to jail for free speech. And that is exactly what this is about. So here's the thing. I'm not going to share the clips. Somebody else can share the clips. And, I don't want to get the stream taken down for sharing the clips. But, like, they actively talked about being pimps. And I don't mean pimps in, like, the way where people are like, oh, I'm a pimp. And they try to, like, that. They try to say that as, like, they're a charismatic person. I mean pimps in the sense of, like, forcing women to engage in sex work. Like, the actual meaning of pimp. And I don't really have a whole lot of regard for people who describe themselves as pimps in a fashion that, like, you know, where they think that's like a praiseworthy thing, because having seen what, like, you know, what is involved with actual pimping, it's pretty disgusting, right? You know, it's like if somebody was trying to say as a badge of honor, like, yeah, I will just have to see what, we'll have to see. But hopefully they get sent back to the UK. Hopefully that, you know, they get to face a full trial for that. And hopefully that's the end of it. So, all right, let's look at super chats and then wrap up. So, Crystal Dagger, no, we love to hear about Kouri. We've heard about Kouri. Tough Cookie, thank you for the 10 gifted memberships. And Honk Banana No, thank you for the 10 gifted memberships. Patricia 1910s is for the beer story. Thank you so much. Been eagerly awaiting your snark with this one. Thank you. Hi, I didn't know you were on. The super chat is to say thanks for staying on. Can't wait to rewatch what I missed. Glad to see you're okay. Thank you. Sorry fading tonight and have an early morning. Good to see you, and good morning when you have it. Michigan Farm Boy, sorry to hear about the flood issues. Just got back from a company dinner, and we'll catch earlier part on replay. Wish you're back well on the recovery. Thank you. The Jet JJ, a few weeks ago, I looked for your Amazon list, but it was in U.S. site. Random Runkle foster family in North Carolina got a gift card in your honor. Whoops. I went to the National Court Reporter Conference last week. I was like, which is that? Oh, right. Astro Melon. Woot, number 19. Soon to be number 20. Honk Banana No. Final, perpetuate your toxic tip culture despite its deleterious effects on the working class. Fair. ASG says, steno practice to your commentary tonight. I just purchased a Pro Steno machine, my first, because my student machine has major issues. Wish me luck. Good luck. Chloe Diagnosed Snarky, thank you. Uncivil says, tell the damn beer story, and I better be good. Fair. Or it better be good. Michigan Farm Boy. Not sure this is the trial counsel, but you can't argue that we messed up / sucked. And the only argument is that it must be someone else's fault, the judge and / or prosecution. It's kind of where we're at. Michigan Farm Boy. Bev wouldn't even let them say what the objection was. She would just pick something she liked. Yep. Or didn't like. Honk Banana No. Just a quick reminder, Bob knows what he did. And try not to think about it. I think Bloodworth said it best in his closing. Kouri Richins is incompetent. Stay dry, Runkle. Thank you. All right. Let's wrap this up. And yeah, I got to get the ring light fixed. I got to get all of that going. And yeah, hopefully get the house working, get all of that. So yeah. All right. Oh, Cootie Pootie Tootie, thanks for doing your videos. I was able to advocate logically for my dad's medical care today because of watching you and your ethical defense. That is a great one to hear. All right, let's wrap this up and see you guys later. I'm going to go and soak in a tub because my back is killing me. So good night, all.